if it's something that the parties may appropriate. But in my practical experience, I've not seen yet this kind of mediation in the construction industry.
Okay, thank you so much. So I think we can take a few questions from the audience now, and I understand some people are online as well. So if you can let us have those questions from online, and then questions from the audience. Yes, can you please pass the mic to the first one?
Good morning. My name is Mary Angawa from Kenya, Africa, East Africa. I was very interested with all your conversation.
If you can speak up, we can hear.
Thank you. Can you hear me now?
Not clearly, but
closer. What about now? That's better.
Yeah, that's better.
Right. Thank you very much. My name is Mary Angawa. I'm from Kenya. I was very, very interested in the concept about the pipeline going from Tanzania to Uganda. I may be out of ignorance, but I was just wish to ask, Kenya has already got a pipeline that stops in Kisumu. Why is it that Uganda can't just attach it to that and finish it? And then the other question I wanted to ask is whether you are aware of the Nigerian situation where a pipeline was put and there's been pipe spill and many people are undergoing, they can't use their land because the oil has degraded it. I don't know whether you could make a comment on that and how this project has mitigated those environmental concepts. I think it's the Ogoni situation in Nigeria, where the oil spill has polluted the water. People can't farm anymore because the soil is so oily. And what have you done to mitigate that kind of concept? Thank you.
Olivia.
Thank you. Did you say Mary? I hope I got you right. Yeah. Regarding why Uganda cannot connect to the pipeline in Kenya, I wish the Minister of Energy of Uganda was here. But I know that previously there had been, the plans had actually been that the pipeline would go through from Uganda through Kenya, but I don't know what happened between the two governments. Another deal was struck with the government of Tanzania. That's what I can say. I hope you can accost Barbara during break. She probably has an idea of how that decision was changed. In terms of mitigation of the effects of oil spills, well, what I have been informed is that in terms of resettlements, one of the ways they've done is that they've ensured that a bigger part of the land, they are going to have people moved and resettled far from the pipeline corridor to ensure that you avoid issues of human life being affected there. So far, that's what I know in terms of the mitigations that are being done to mitigate the risk you talked about. Thank you.
Does that answer your question, ma'am?
Good morning. I'm Kiza Lillian from Uganda. In addition to what Olivia has just answered, would also like to take cognizance of the fact that we are doing a heated pipeline. So I'm not sure the one in Kenya is heated or can be converted to that. So that would explain part of the reason why the conversion happened. Then also, secondly, mitigating factors are with a heated pipeline, once there is a spill, the oil immediately waxes up. So it would not be able to disturb very many people all over because it solidifies. And that's why we have a heated pipeline. So if it breaks a bit, it will wax up, solidify, and the community is not affected so much. Thank you.
Yes, thank you so much. Agnes is looking directly at me now. So one more question. The gentleman there.
Thank you very much. My name is Tolu Adereme. Just like the moderator, I'm also Tolu. And I'm a partner with Patchstone and Grace in the London office. My question will go to Jackwell, and then the later part of it, maybe Olivia can, just jump in and help us with it. Jackwell, I thank you very much for that presentation, and I think it was very clear. In your summary, I could tell that there was a lot of focus on power generation. And I say that's a big area where you play in South Africa. And so thinking through it, I realized that South Africa, across the continent, is the biggest country, or is the country that generates the highest in terms of power generation. And I wanted to find out, as an expert that you are, why is that the case in South Africa? Is it because you have the right pricing? Because I hear or I read that you generate about 58,000 megawatts or 40,000. There's some controversy around that. But my big question is, why has South Africa been able to achieve that? Is it as a matter of pricing? Because if you look across the continent, the question of pricing, either of gas or of generated power, is a big issue. So in Nigeria today, we are now discussing about the aggregator model, where you now pay the gas supplier using that aggregator model. Now, this, to my mind, appears to be a disincentive to the gas producer. And that takes me to the question which I think Tolu asked, the question of the take or pay. The question of the take or pay, most people will agree with me, appears also to suggest that is a clause that tilts more to the side of the gas producer. And again, appears to be a disincentive. Reason because where the gas producer does not supply enough, there are mechanisms within the contract that allows the gas producer to supply much later, but nothing to the off-taker. So should we start thinking of a take and pay clause as opposed to a take or pay clause? And I think Olivia can also jump in on that because it also affects oil and gas transactions. My last question, and I see Mr. Chairman, almost going to shut me up, but I'm just going to close on this. My last question is, Olivia, thank you very much for the presentation on the pipelines. First, I think it opens up opportunities for many of us who may be looking along that line. But I ask myself, those pipelines or the pipelines, are they first government owned? Secondly, do you have the possibility of having private players also plug into those pipelines such that you have a commingling of transportation of crude oil? Now, if that is the case, and that's the case in Nigeria, if that is the case, then there's likely to be disputes because at the, I think it's called the flinch end, where you take out your crude oil, it's usually never adequate or complete in terms of volume. What is the best dispute resolution mechanism that you will propose in resolving these disputes? Thank you very much, Mr. Chairman.
Yeah, thank you. Thank you so much. That's where you get when Tolu is moderating and Tolu is asking a question. Please, Jacob.
Thank you, Tolu, for that question. So I'll try and answer the two questions. So some of them are policy decisions, some of them are structural government issues. So when we look at South Africa in terms of the history and context, from a power generation perspective in particular, so most of the power stations that we currently have are power stations that have been developed and constructed prior to the new dispensation. So that means it's prior to 1994 when the new democratic government took over. So there are several other power stations that have also been developed post that. but those have taken much longer to get off the ground. So I think the two coal-fired power stations, Kusile and Medupi, was commissioned for construction more than 10 years ago, and those power stations are still under construction because of various issues. So the first answer is structural in terms of how the economic system in South Africa operated prior to 1991. So there was significant investment in coal-fired power stations. And at some point in time, if you look at it in the 2000s, the cost of electricity in South Africa was actually very cheap. And that also, so if you have cheap electricity, it means you can also have an industrial base. So you have manufacturing, industries can develop, and so on. But as time has gone on, so the cost of electricity in South Africa has actually significantly also increased over time, because also in the lag of investment in newer generation of power resources for various reasons. So either, again, there's environmental issues where government has had plans to invest in nuclear power stations. So there's three nuclear power stations the government has planned. We've been involved in those processes, again, assisting government in defending environmental authorizations granted for nuclear power stations. I think it was a 3,000 megawatt facility close to the current Kuberg facility. So there's various issues, but the cost is still, it's gone up significantly, but we also have our constraints. As you know, we suffer from currently chronic load shedding, and that is an indication, although you mentioned the installed capacity. So we have installed capacity, technically installed capacity of about 45 to 50,000 gigawatts. Of that, I would say probably only 50% is operational for various reasons, either old power stations that needs to be retired, and also the lag in terms of getting new power stations online. And from a renewable energy perspective, there's a very good program the South African government has run, the reprogram in terms of incentivizing and investing in solar, wind, and other forms of renewable energy, which is assisting the grid. So it's structural policy. We need to do more actually to make sure that the cost now gets reduced, and I think that needs to be replicated also from an African perspective in terms of developing power stations, but not just developing power stations, also investing in transmission lines, because you can't just have power stations without transmission lines. And then on your second question, the issue of take or pay. So that's ultimately an issue of negotiations, I would say, between government and the private sector developer in respect of whether it's for a water plant, whether it's a power generation facility or transmission facility. Because the future, what we see is also currently we get mostly utilities own transmission infrastructure, but the future that will happen is we currently get independent power producers. We'll probably also get independent transmission companies. Because you would incentivize private sector companies to invest in those. But it's all about negotiating the terms and conditions, take or pay or take. But for the developer, it would be, for me to develop any massive major capital project, I need to make sure that, because remember, the investment that an investor gets is also, there's loan funding, there's equity funding. So they would want to make sure that whatever funding that they get to invest in the country is secured and guaranteed. So the take or pay is to make sure that ultimately they can service their liabilities at the end of the day. So, but there's room for negotiations.
Thank you. Olivia.
I hope, as possible. I hope in terms of the first arm of the question regarding oil and gas, his answer satisfies the issue about negotiations and the justification for why it would be take or pay or take and pay, depending on the contracting party. So I think you've addressed it. Now, in terms of ownership, and I'm happy that Barbara is here. If I can't do it, she'll do it. But what I know is that the ECO project has partners. Like I said earlier, the government of Uganda is represented by the Uganda National Oil Company. And then you have the government of Tanzania, represented by the Tanzania Pipeline Development Company. And then you have CNOC and Total. So those are the project partners. We haven't looked at the shareholder agreement. Like I said, they are sealed agreements, but my presumption is that in that agreement, their shares and the ownership of the pipeline is within those agreements. And therefore, probably it's not entirely government owned, but there are different portions that are being owned by both the governments and the project partners. Then in terms of dispute resolution, I had the question towards the end. I assume you wanted to know what's the most appropriate mode to take in the oil and gas disputes. Well, we're at an international arbitration conference, so I guess I would say arbitration. But useful. Most importantly, because of the expertise, I dare to say that probably our local courts or the judiciary are not yet they haven't yet built capacity in oil and gas dispute resolution. So I think we are safer as a community taking these disputes in arbitration, where we can choose experts in that area to determine the disputes they are in. Thank you.
Thank you very much. Did you say I can take one more question? Yeah, the gentleman at the back, at the very end.
I'm Dr. Usman Kumo from Nigeria. First of all, there is a lady that asked of oil spillage in Nigeria. Just information that the Nigerian government has set up what they call HYPREP, Hydrocarbon Pollution Remediation Project, and issues like that have been attended to. My question here, sir, is in Nigeria, no much arbitration is needed in generation and distribution. The problem we have is the consumption. There is what they call estimated bill. In almost 80% of the local governments in Nigeria, estimated bills are being issued. What is an estimated bill? In my house at the village, I don't get power for more than 100 hours in a month. And I am being given an estimated bill. Whether I have the power or not, I have to pay. So this is the area that arbitration is needed in Nigeria, in the consumption, not much in distribution and generation. So please, what are you people going to do about it? Thank you.
I think I can answer the question. So in the area of estimated bill, one of the biggest problems is that gap between generation and consumption, which is the ability to distribute. So the government, you're generating, but you don't have the infrastructure to be able to efficiently distribute. And that's why what you have, and because you are unable to distribute, you have epileptic power supply. And so at the end of the day, you end up doing estimated billing for the consumer. So the problem I still think is closing that gap between generation. Yeah, we don't have enough. We have installed capacity to generate, but then we actually don't generate enough. And then we have the problem of the capacity to distribute what's generated. So that, I think, it goes a long way in contributing to the problem of estimated billing. But there are other experts in the field who are in the audience who can speak to this. I think, Godwin, you wanted to say something. Tolu, I will be so, I shouldn't allow you to speak. So, okay, please go ahead.
And I promise not to waste your time, Tolu. I think on the question the gentleman at the back asked, I think it was very clear as to what is the best method of dispute resolution for those who are giving estimated bills. Let me start by saying that I think it's almost unacceptable in Nigeria now to be issued with an estimated bill. And I think that's a starting point, because the government is spending a lot of money rolling out mass meters across the country. But let's even assume that you are issued with an estimated bill and you want to contest it. Most of the times we tend to contest it because they're never accurate. Under the Electricity Regulatory Act, there's a clause, or there's a provision, I beg your pardon, that creates a tribunal, which is at the state level and then at the national level. And so where you start with your district, what I call your district power station, and you're unhappy with it, at the NERC level, there's also that tribunal where you can raise this concern, and it will be resolved. For a little fee, I can guide further, sir. Thank you.
Thank you so much. I think, yes, you wanted to intervene. Please go ahead. Barbara.
A very good morning, everyone. All protocol observed. I think I need to support Olivia on some of the questions that were put before her as somebody who is from the industry. I think also this is a very good opportunity for us to continue popularizing the East African crude pipeline so that everybody can say something positive about it. We have had a lot coming through from the environmentalists saying, no, this is actually going to displace people. We don't need this pipeline. Why don't we tap on the rest of the pipelines that exist within the region? So just to add my voice and clarify some of the aspects, in terms of the question that was put forward by Mary, if I got your name right, she was asking why not Kisumu, why not Kenya, and why Tanzania? I'm not the Minister of Energy, but I will just say that a lot was done. There were many feasibility studies that were undertaken to determine the route through which the Ugandan pipeline would be taken through, because we're in a landlocked country and we need to tap into the countries that are near the sea, and we had an opportunity with either Kenya or Tanzania. Ultimately, His Excellency, the President of Uganda, following all the reviews that were done by the technical teams, all the engagements were done with Kenya and Tanzania, a decision was made in April 2016 that the best route for Uganda would be Tanga. And part of the rationale behind it, as was articulated or alluded to in that official communique that was put forward, was one, how many people would be impacted, the tariff that was going to be involved, because we also want to be cost efficient, cost effective, but also environmentally sensitive to the communities. So the less populated area ended up being from Kabale through to Tanga Road. And that's how it ended up, among other reasons. That's why it was chosen by His Excellency, the President of Uganda, after deliberations with Tanzania and also Kenya. So in terms of the other question that was put forward regarding private parties benefiting from this pipeline, tagging into it, I just want to note, yes, as much as the two governments of Tanzania and Uganda, they have shareholding in ECOP as a company, the private entities were pointed to by Olivia. There is SINOC and there is Total. But also the law has provided for third-party access. So yes, indeed, we are trying to explore, as you noted that so far what has been discovered will run out in a number of years, say 30, 40 years. We need to be exploring more so that we don't have white elephant infrastructure in place. So yes, third parties will be able to tap into this pipeline and there will be clear protections for them. There will be no discrimination. Certainly the quality of their crude will have to be checked to avoid the disputes that will come in terms of the commingling and the impact of that, because there will already be existing long-term contracts with the existing parties that own the pipeline, with whoever will be buying, all the off-takers that will be taking this crude from Tanga. In terms of environmental protection, a lot has been done to try and ensure that basically this project poses a net zero impact. And how are we going to do this? The quality of the pipeline is 24 diameters, it's double, and also it is insulated. Through the control room, we are going to be able to monitor what will be going on with the pipeline to minimize or mitigate on opportunities of pollution happening without anybody noticing. So a lot has been invested or done in terms of the designing of that pipeline to ensure that its impact on the environment is minimized and the impacts are really mitigated. In terms of the arguments around displacing people, I would want to say that we have also done a lot in that area to make sure that we are just not even going to compensate people based on the Ugandan laws, or on the national laws in Uganda and Tanzania, but rather also we are looking at the IFC standards. What are the expectations? So the compensation has a markup that matches with international expectations or standards. So whoever is going to be displaced will be paid a top up or a margin that is above what is expected. But also within the country, we have come up with so many policies and guidelines. The environmental studies have been done and they've been approved in both Uganda and Tanzania for the project. We have had an oil spill contingency plan that has also been developed. So there is a lot, and the impact that is being alluded to probably that is out there in the public arena is not factual. I think there is need for us to understand the mitigations because we have learned a lot from the existing pipelines that do exist within the world, which exceed 2,600.
Thank you. Thank you so much, Barbara. That's very helpful. So I think we've come to the end of this first session, and thank you so much for your participation, and join me in thanking the speakers. Hand over to you, Agnes. Oh.
Thank you so much to the panelists. I think we are again running out of time, but let's have a 15 minutes healthy break. We'll be right back for the second session. Thank you.
Stuck on you, got this feeling down deep in my soul. Just yes, I'm on my way. Needed a friend, and the way I feel now, I needed a friend, and the way I feel, yes, I'm on my way. Yes, I'm on mighty glad to stay away. And I know just where I'm going. Packed up my troubles and I throw them all away. Cause this I'm in dark. I'm coming home to stay. I'm stuck on you. Got this feeling down deep in my soul that I just can't. Yes, I'm on my way. Oh, and I need a friend. And the way I feel now, I guess I'll be with you till the end. Yes, I'm on my way. Mighty glad to stay. I've been looking too hard, I've been waiting too long. Sometimes I don't know what I will find. I only know it's a matter of time. When you love someone, when you love someone, it feels so right, so warm and true. I gotta know if you feel it too. Maybe I'm wrong. Won't you tell me if I'm coming on too strong? This heart of mine has been hurt before. This time I want
So the person who is speaking.
someone new to make me feel alive. Yeah, keep his mind on nothing else. He takes the world, the birds in the sky. And she is bad, he can't see it. He can do no wrong. Turn his back on his best friend, he puts her down. When a man loves a woman, spend his very last dime trying to hold on to what he needs. He give up all his comfort, sleep out in the rain. If she said that's the way it ought to be. When a man loves a woman, I give you everything I've got. Gonna hold on to your precious love. Baby, please don't treat me bad. When a man loves a woman, deep down in the soul, she can bring him such misery. If she's bad from a fool, he's the last one to know. Love that I can never see. It's when a man's like a woman, I know exactly how it feels. Just baby, you want it, you can. Oh, yeah. By the
Hello. Can we be ready, please, for the second session? Please have your seats. Let's prepare for the second session. Let's get seated, please, for the second session.
Yeah, I think it's a good idea.
Please, let's prepare for the second session. Please come in for the second session.
Like at the theatre.
The pastries ran out in like a couple of minutes.
There was no sign of any couple of crumbs.
Yeah.
Last week I went to a child, my cousin and his wife, and they got a 1-year-old, just turned 1. And we went.
Thank you. Thank you. Thank you. Thank you.
Dear participants, we are now starting our second session, and I'm happy to introduce our next moderator for the second session. The moderator for the second session is Mr. Jide Adesokani, partner at Stevenson Howard, UK. Please be seated. We have a packed program. I hope we'll be able to use our time well. Thank you, Stevenson. Oh, no, Jide.
Good morning, distinguished delegates. I will be standing on all protocols observed so far this morning. I'm happy about three things today. I'm happy we're back in person. I was at the 2019 EAC conference, which was great. So that's one. I'm happy to be in Kigali for the first time ever. I arrived last night. So it's my first time in Rwanda, and I'm happy about that. And we at Stevenson Howard are very happy to be supporters and sponsors of EAC, and to have supported and sponsored EAC since its inception. I think you see 9 years ago. A lot has changed since 2019. I want to start with a true story. Exactly a week ago today, I bought a car. I bought a used car. It was a decent car. I'm happy about it, or I thought I was happy about it, until I discovered something. And this is that the model of my car that I bought did not have a key feature that older models of the car had. And so I was very upset, and I was, angry at the salesman because he didn't tell me that it didn't have this important feature. And when I asked him why, he said it was due to the supply chain issues that are ongoing in the world. These are some of the issues we'll be looking at today. I'm sure when Leyu and Elodie and Agnes were thinking about what insightful topics they would have, if they discussed that last year, COVID probably would have been on the agenda. I don't know that supply chain management issues would have been on the agenda, and certainly the Ukraine situation would not have been on the agenda. So a lot has changed. That war is now a permanent feature on our TV screens. It's affected East Africa, it's affected Africa, it's affected the rest of the world. So we have three speakers who will be exploring some of the issues arising from this double or triple whammy: the COVID, the pandemic, the Ukraine war, and supply chain issues. I'll introduce the speakers and then we'll go straight into it. So first of all, we have Dr. Bernd Ille. Ille? I did well, thanks. Bernd is a partner at the Leave of the law firm operating out of Geneva, Zurich, and London. He specializes in international arbitration and has acted as counsel and arbitrator in more than 80 international arbitrations, investment arbitrations. Bernd also spends a lot of time in East Africa, which is obviously relevant for today's conference, and has done a significant amount of work in Kenya, Uganda, and Tanzania. Followed by Bernd will be Alistair. Alistair is a barrister practicing at Four Stone Building, Chambers in London. He's been working on Africa-based disputes for over a decade, and particularly spent a lot of time working on disputes arising out of Rwanda. I mentioned that it was my first time in Rwanda when I arrived yesterday. Alistair just told me that this is his 40th trip, or over 40th trip.
Lost count, but yeah.
So Alistair has done a lot in Rwanda, and we'll certainly be interested to hear from Alistair on how global uncertainty impacts the flows of trade and investment into Africa. Last but not least is Flora Jones. Flora is a senior associate specializing in international arbitration. She practices at King & Spalding in London, and she has a particular focus on the energy sector. Flora has acted as counsel, including recently, I'm sure, in international arbitrations under most of the major institutional rules. And so Flora is therefore very well placed to speak to us on what lessons there are to be learned and new opportunities to be exploited in view of the pandemic. I'm going to go straight to Bernd. Bernd is going to be talking to us, and is very well placed to talk to us about the effects and the potential for disputes arising out of disruptions in the global supply chain. So I'll hand over to Bernd straight away. Bernd.
Thank you very much, Jide. And Maramutse, bonjour.
Good afternoon. It's already afternoon. It's my pleasure and honor to be addressing you today on the issue of supply chain disruptions. Just waiting for my slides to come up. The title of this panel is The Double Whammy, but the situation the world is finding itself in is actually more than just a double. There are 4 C's, and you will see them on my slide. Seconds. Makes more sense to look at the slides while I'm speaking.
Excuse us.
Yeah. So apparently there's an issue with my slides. Too bad. So we'll simply go ahead without the slides. So there are 4 C's. The 4 C's are climate, COVID, cash, and conflicts. So obviously COVID and all of these 4 C's form the perfect storm that the world is finding itself right now. They're all at the same time, and they're leading to an unprecedented disruption in the supply chains globally. The obviously conflicts, we have the Ukraine conflict now with Russia, and that leads to lots of supply chain disruptions. There's one example, I talked the other day to the General Counsel of Coca-Cola Central Asia, and she said there's no more sugar available, and obviously sugar is one of the key components to Coca-Cola. I read somewhere that nails are primarily produced in Ukraine, and now there's a shortage in wooden panels because you cannot produce wooden panels without nails. COVID, the other C, leads, just one example is the zero COVID policy of the Chinese government. And many of you will have seen the pictures of these hundreds or maybe thousands of ships waiting outside of the Shanghai harbor. Then we have climate related issues, floods, droughts that lead to supply chain disruptions. And also cash, inflation all over the world. Inflation is on the rise and leading to financial distress. And in addition to that, there are transportation failures. Just remember last year, this ship, the Evergreen in the Suez Canal, there was a major disruptor to the global supply chains, and Brexit, and there are other examples. And all of these disruptions have pushed the global supply chains to the brink and affected everyone's daily life. So the effects, I had a nice list on my slide, the effects are far-reaching and rarely localized, and they go into all sectors. They spill over. If there's one sector that is, here we go. If there's one sector that is affected, if we could go to the second slide, please. Next one. So this was the perfect storm I was speaking about. And next one, please. Okay, so the spiraling effects of the supply chain disruptions, many different things, obviously reduced production, delays, logistical disruptions, price increases, labor shortages, and all of these things. And obviously also disputes. So there's the businesses in the world are obviously trying to adjust and to adapt to this new situation. And they will make sure that their supply networks are more resilient to disruptions, and they will diversify and find alternative trading partnerships. There will be more risk monitoring going on. And generally, there will probably be some sort of decoupling or deglobalization going on. But inevitably, right now, while this is ongoing, there will be disputes of different natures. Next slide, please. So the potential for disputes is enormous. And obviously, the disputes might be over the liability for non-performance, different kinds of non-performance, from delays to payment, but also the consequences that one party may have to bear, the consequences of losses downstream in the supply chain. There will be disputes or are disputes about compliance with the often short notice requirements. The burden of proof, very important. It's difficult to show the causation of a certain development on the supply chains. And that was a bit too quick. Could we go back 2 slides, please? Next one. Next one. Thank you. Oh, too quick. And also the duty to mitigate. And another kind of dispute will be about the availability of the remedies, that obviously the contract is the starting point. The parties, if they're lucky, they may have clauses in the contract that deal with price escalation, that deal with changes in law. Changes in law was one of the primary contractual clauses parties relied upon in relation to COVID, because there were local government restrictions, and those often, depending on the local law, would amount to a change in law. And penalties and liquidated damages, force majeure, we heard about force majeure this morning. One important, in the context of supply chain disruptions, I think an important remedy are the statutory or the non-contractual remedies of hardship and frustration under civil and common law jurisdictions. But the threshold for these is usually very high, where you have to prove that there was a change of circumstances, an extraordinary change of circumstances, and that this change was unforeseen. So the threshold is very high. And next slide, please. So in this context of these global supply chain disruptions and these many disputes, or the potential for many disputes, it is important that arbitration and ADR generally fulfill their mission to help parties in this context. And one of them is contractual adaptation, which means the parties sit down together and they find a solution. That is also what is under hardship and under frustration. The idea is that the parties try to find a solution because they know best what their interests are, and they can do so also with the help of mediation. If that does not work, then they move on to ways of urgent relief. I've listed a few on this in the middle column of this slide. And if all does not work, to normal full-fledged arbitration. And there's an important feature in arbitration, that's the flexibility of the process. And I believe that this flexibility should be used to make sure that the parties can find ways of joining or consolidating different arbitration proceedings between different members in the same supply chain to make sure that there is no conflicting decision. So these are my points, and they're summarized also on the last slide. Thank you very much.
Thank you very much, Bernd. We're happy to have questions if there are any from the audience and distinguished delegates, but I'll kick it off. Bernd, there are businesses in the room, and they would have heard your helpful presentation. They would want to know what should they be doing to protect their interests in the face of the global supply chain issues?
I think the first point is that these businesses should identify exactly what the scope of the supply chain disruption is and identify the causes, and then take an informed decision how to minimize the risks and how to maximize their rights in the face of these disruptions. Another important point is that parties should be mindful of the notice requirements under the contract. Oftentimes, for example, in the construction industry, under the FIDIC contract, there are very strict notice requirements, a few days or a few weeks' time. Parties should also look at the insurance situation, if that can be helpful. And I think one of the most important points is to make sure to collect all the evidence, all the documentation that is needed to prove the crisis-related impacts, because when there is an arbitration at the end of the day, these parties will need to prove causation, and that is, as I said earlier, is a difficult task. And the more contemporaneous documents they have, the easier it will be to prove their case.
Thanks, Bernd. Still open to the floor if you have questions. I have another question. Again, it's in relation to the businesses in the room. They've heard about the different ADR mechanisms, and they obviously don't want to get to disputes, but in your view, which of the ADR mechanisms is most appropriate, most commercial for resolving these supply chain disputes?
Frankly, I think in the situation of a supply chain disruption where the whole supply chain is at risk, the parties should make a true effort to sit together first and try to sort it out between themselves. That's the most cost and time efficient way of doing that. If possible, if they cannot do it just between themselves with the help of a mediator. And if that doesn't work out, but that's probably the most cost and time efficient, then they can move on and move to the two other columns that were on one of my slides and use these expedited ADR proceedings or expert determination, dispute adjudication board, and so on. So it is obviously crucial that a solution is found quickly in the face of these disruptions, because otherwise, as I said, the effects are very far-reaching. There are ripple effects spilling over into other industries, and the quicker this can be sorted out, the better. And then obviously the advantage of arbitration as a dispute resolution mechanism would be this possibility of joining or consolidating proceedings, joining parties, that to make sure that there are no contradicting decisions, because that would be harmful to the whole process.
Thank you very much, Bernd. Are there any questions for Bernd from the floor? I will take silence as my approval to go ahead, which I will. So we're going to move on to Alistair. I mentioned Alistair's significant experience in disputes, certainly in this country and on the continent. Alistair, I'm going to ask you some questions, and we'll use that as a segue to your presentation. So could we have Alistair's slides, please? And whilst Alistair's slides are being put up, I'll ask the first question. Alistair, what do you think, based on your experience, are the current threats to investment in Africa?
Okay, thank you, Jude. So, I mean, I think just to give a bit of overall context, and what investors are looking at and what investors are influenced by when looking at investments in Africa. I mean, the real background context is that, there is and there remains a regional risk premium for investors looking to invest in Africa. And that's for the obvious reasons, things like security of property rights, legal certainty, concerns about fraud and corruption, which to a greater or lesser extent, rightly or wrongly, are matters which concern investors investing across Africa. Obviously, in some countries more than others. So that's a background factor that hasn't changed. We've obviously then had the COVID-19 pandemic, which has caused all the disruptions that we've been hearing about, has caused lockdowns, economic effects in countries, which has affected the economies, consumer consumption. But that seems, from my understanding, to be actually bouncing back. Africa has dealt remarkably well with the COVID pandemic. I mean, Rwanda, for example, I was talking to somebody the other day, the rates of vaccination in Rwanda are as high, if not higher, than the rates in the UK, which is a remarkable achievement. So COVID-19, obviously, that's probably what we thought we would be talking about. But we are now facing the other elements of the double whammy. So we've got the general global economic factors and the winds that are blowing in terms of inflation, the effect of equity market weakness, which has led to reductions in liquidity, collapse in valuations, investors having to look at their portfolios, reconsider, perhaps consolidate, perhaps keep capital aside in case they need to invest in order to bail out or support businesses that they already are invested in. So there's certainly less capital around for those to invest in. And then on top of that, we have the effect of the Ukraine conflict and the way in which that has had an effect over the last 3 months on global markets and on the global investment appetite, both positive and negative. And I'll come on to say something about what I think are going to be the positive effects for Africa from the Ukraine situation. But all of that, generally speaking, and again, as a matter of background context, has led in the global investment environment to a flight to safety for investors. So investors are now increasingly looking at low risk investments. They're looking at moving capital into government bonds, into real estate in safe places like London and New York, etc. So all the classic behaviors that one sees from investors who are worried about protecting their capital. And last week I made a few calls to contacts and friends in the investment community with interest in Africa in particular, and asked them, just did a bit of a straw poll as to what the climate was like, what they were finding. And generally the feedback was that from a few people who've been trying to do investment rounds this year, that it's definitely harder to capital raise at the moment because of all of these factors. And where capital is being provided, it's being provided on more onerous terms than before. And of course, that's understandable. But one of my contacts has got a very good agricultural business based in Ethiopia. So they export huge volumes of flowers to Amsterdam to be sold in the Dutch and the European market. Really good business, good margins, and they found it very difficult to raise money despite having a business which is fundamentally sound. They've got a great track record as a business. They're finding it difficult. So that's anecdotally, but I think that's not surprising. But as I'll come on to say, I think there are some reasons for some optimism.
Thanks, Alistair. You've mentioned this, the conversation with your friends and the difficulty in raising capital. We're aware of the difficulties or the predicted difficulties of the price of wheat and that sort of thing in, affecting Africa. What, if anything, are the positives, the opportunities that you see?
Yeah. Okay. Well, if I can have my second slide up, please, on the PowerPoint. I can move the next one, please. Okay, so that's what I was just talking about in terms of the general threats to investment. If we could go on to the next slide, please. And some of the reasons I think to be positive about investment in Africa and the effect of the current external difficulties. I mean, I think the starting point is that Africa, in a way that is not reflected in other areas of the developing world, other developing economies, a significant proportion of African investment is DFI investment. And that tends to be longer term, it's government backed. And as we saw during the response to COVID-19, entities like the AFDB and Afrexium have been very quick and very responsible in the way that they have leapt to try to support Africa as a whole. So I think the AFDB had a 10 billion fund, which was opened up in March 2020 at the beginning of COVID. Afrexium, I think, was about a 3 billion trade impact fund to mitigate some of those difficulties. And I expect we will see similar responses and are seeing similar responses to the crisis now being brought about by Ukraine. And that's something which is particular to Africa, as I say, which other parts of the developing world don't really have. Then there's the geopolitical aspect to all of this. So another background factor, which was already a factor, is the way in which the West has been trying to counter the influence of China in the region and the Belt and Road Initiative. I mean, China, is actually reducing and has reduced its investments in Africa recently. So I think in 2020, which is the most recent year I could find figures, but the lowest investment by China in Africa since 2004, so down to 1.9 billion, which is a very significant drop from previous years. And China, of course, is suffering from its own difficulties with COVID. But I think that's giving an opportunity to to the West to now step in and put in place certain initiatives and certain funds. So we've seen the G7's Build Back Better World Initiative, then at the EU Africa Union Summit earlier this year, February, I think it was, there was a pledge for 150, I think it's a million on the slide, but it's 150 billion investment over long-term investment. The UK, for example, has recently announced a 1 billion fund for investment in Kenyan infrastructure. So these are all being driven, or largely being driven, prior to the Ukraine conflict, by geopolitical issues and by the West trying to bolster its influence in the region. And that's going to continue, particularly now we may have something of a hiatus with Chinese investment, largely driven by what's going on there, and potentially with them also the impact of their relationship with Russia. So those are some background factors. If I could have the next slide up, please. So as a result of the Ukraine crisis in particular, we've now suddenly got a big interest in food security. The grain market has been impacted by Ukraine and the lack of availability of grain from Ukraine. Fertilizer supplies from Russia, because of the sanctions that have been in place, that's been very strictly limited. And so there's now an increasing focus on growing African food production so that Africa can become at least more self-sufficient in food production. The basics are there. There are the available arable lands. Over the last few years, yields have increased, and now biotech and food tech are increasingly coming on the scene, providing obviously opportunities for increasing yields, but also opportunities for investment. And a McKinsey report published in 2019 estimated that Africa could, with the right investment and the right infrastructure, could triple cereal and grain production. So that's by making investments in irrigation, in fertilizer plants, in storage, in transportation, and in general mechanization. So there's a huge potential there. And I think the focus now is very much on trying to do that and trying to move away from not just an African, but particularly Western dependency on grain supplies from Ukraine in particular. And we've seen this, in fact, in the food tech sector already, and this is probably because it happened around the same time early in this year, before the Ukraine effects were really felt. But a couple of examples I've cited here: Apollo Agriculture in Kenya raised 40 million of equity finance. Thrive Agric in Nigeria raised 56 million in debt financing. And those are both entities which are helping smallholders. They're helping to create the efficiency of agriculture within those countries. And there are other similar types of projects which are also attracting money. In the fertilizer industry, there's a huge investment announced in March. So again, not a consequence directly of what was happening with Russia and Ukraine, but something surely that will provide something of a blueprint. So in Nigeria, again, a $2.5 billion investment in a plant which opened in March. And again, I think we can increasingly see Africa becoming a location where things like fertilizers are going to be produced. And then we've got the energy sector. So obviously now with the difficulties with obtaining or trying to wean the West off Russian energy, a real focus on energy from Africa, and can Africa step into the gap in some ways and provide energy that can help wean the West off Russian gas and oil. So I mean, again, and already in the pipeline, but one can expect to step up the investments being made in non-renewable. So the Tanzania and Mozambique gas fields, there's about $30 billion of private investments going in there in those areas alone by 2030, led by the French and the Italians, Total and ENI. And then there is renewable industry, which is obviously, and we heard earlier some of the speakers talking about climate change and the environment and balancing all of that. There's now access to climate finance for projects in Africa. We've seen a recent agreement between the EU and Egypt to do something in the green hydrogen space with something called the Mediterranean Green Hydrogen Partnership. So those are all very, very positive developments. They're already there, but I think we're going to see increasing focus on those and increasing diversion of investment into the African market to try to support the energy sector. And then, finally, if I could have my last slide up, please. And entirely independent of this, I think, I mean, fintech had a massive year last year, and probably some inflated valuations which have come down, but fintech is really still, Africa is still really a crucible for fintech businesses. It's got a young tech savvy population who are very comfortable, who've grown up using mobile payments. So it's the perfect place for fintech companies really to grow and thrive and then spin out from Africa elsewhere. And we've seen some significant investments. Last year, SoftBank led the $400 million investment in OPay, and that's continued this year. There have been a couple of significant investments in particular, and then there are other fintech companies like Chippercash and Flutterwave, which are attracting lots of attention. So I think that sector is going to remain resilient, and that's going to continue to attract investment for the foreseeable future. So lots of reasons, I think, to be positive for various different reasons.
Alistair, thanks very much for that. That's really useful, and I hope the slides will be circulated later on, because it does give you, I mean, I've always said, if you follow the money, you ultimately get to the disputes and get to the arbitration. In those areas, fintech, food tech, like you said, probably areas we're going to be seeing disputes in. I spoke to someone recently who was talking about doing a cryptocurrency arbitration, which sounds very complicated. And I don't want to be involved in that sort of thing, but I'm sure, I mean, if one were to look at it, there will be disputes in that. But we're in a room full of arbitrators and people who've had to experience the new age of arbitration during the pandemic. Flora Jones is going to talk to us about the lessons to be learned, the opportunities that there are coming out of arbitration during the pandemic. Flora, thanks. Can we have Flora's slides, if possible?
Thank you, Jide. And I want to start by saying that it's a real honor to be speaking on this panel today, and it's just great to be back in Kigali. I first came to Kigali in 2009 to teach English to school teachers, and that was before I'd even started studying law. So it feels like a very long time ago, and I feel really lucky to have the opportunity to come back. So thank you for having me. So my topic today is lessons and new opportunities in arbitration from the pandemic. Now, that is a very broad topic. The pandemic has had a really serious impact on almost every aspect of arbitration. Given the time constraints today, I want to focus on one aspect, and that is the hearing. And that's because the hearing is obviously a key stage in proceedings, but it's also an element of arbitration that has been very significantly affected, but also to a certain extent permanently affected by the pandemic. So I'm going to start by talking about some lessons, what we've learned, specifically what are the advantages and disadvantages of virtual hearings, and then I'm going to outline some opportunities. So if I could move to the next slide. Starting with the advantages, I think one of the key advantages of a virtual hearing is the flexibility. It's much easier to organize a virtual hearing, and that's because it's much easier to find a mutually convenient time for all participants to join. And that's because they take up less time because nobody is traveling around. And in an international arbitration with participants around the world, that can be significant time spent traveling. And I think the key benefit here is that it has the ability to speed up the process and also to avoid some of the unfortunate delays that are caused by scheduling issues. Another advantage of the flexibility relates to expedited processes. Bernd already touched on the urgent relief and how that's an important aspect of arbitration. And before the pandemic, we did use telephone conferences, but I think the ability to convene a virtual hearing at incredibly short notice, sometimes within 24 hours, is a real improvement. The other two advantages I've listed are efficiency and cost, and they are both very important, but given the time, I'm going to move on now to the disadvantages. So if I could move to the next slide. Now, one of the key disadvantages of a virtual hearing relates to technology. There is a requirement for lawyers and participants in a virtual hearing to have very high-speed internet and reliable internet, a high-quality camera, the software that you need in order to deal with an electronic bundle, and as many screens as you can get your hands on. I think you need at least 3. You need one for the transcript if there is one for the bundle, and at least one so you can see the tribunal on screen. Now, while having those having that technology is a given at the big international firms in London and Paris and Singapore, that's not a given in all places in the world, and some law firms will simply not have access to that technology, and so they're at a disadvantage. And obviously, one of the key aims of the East Africa International Arbitration Conference is to ensure that all participants and the participants from East Africa can compete competitively. So I think this is a really important consideration. The other issue with technology is that even the most advanced technology can and does go wrong. So I've seen arbitrators whose iPads have run out of battery and there's been a long delay while they've had to find a charger. I've also heard of an arbitrator whose Wi-Fi was cutting in and out, and he said that the signal was better outside in his garden. But because it was raining, because it was England, he actually had to sit under an umbrella, which was obviously not ideal. I think that another disadvantage for the tribunal is not having the witness sitting in real life in front of them. I think the virtual setting does have the capacity to create a bit of a barrier between the tribunal and the witness. And I think the short point is that it's harder for arbitrators to assess the credibility of a witness when they're on the screen. And obviously the importance of the credibility of the witness is, that's going to vary between cases. In some cases, it may be fairly insignificant, but in other cases, it may be key to the case. Sorry. The witness not being there is also a disadvantage for the advocates. I think generally speaking, advocates find it much harder to cross-examine a witness when they're not in front of them. In order to give the impression of eye contact, you actually have to stare into the little webcam, so you miss out on the facial expressions and the reaction of the witness. It's also a disadvantage to the witness themselves. One of my colleagues likens entering into a hearing room to entering into like a church or a religious space, in that it instills a sense of seriousness and gravitas to the scenario. And I think also most witnesses feel fairly daunted by the prospect of having to look into the eyes of the arbitrator and answer questions. And I think the contrast to when witnesses are giving evidence from home is that there's a worry that they may not be as prepared and they may be more distracted. So one of my colleagues recently had to cross-examine a witness who was on holiday in Cornwall on the coast of England. And it was just very, very clear that he didn't want to be there. His kids were in the background, the dog was barking, the sun was shining, the beach was beckoning him, and he just wanted the process to be over. And it was quite clear that he wasn't really very prepared. So I think there is there's the possibility that the quality of the evidence might be impacted. Another disadvantage is that communication is much harder in a virtual hearing. And I think this is most relevant perhaps for the tribunal, because the legal teams now are more often than not sitting together. But it's harder for the tribunal. I think in the pre-pandemic days, ordinarily, the night before the hearing, there was the opportunity for the 3 arbitrators, if there was a panel of 3, to meet and discuss the case. Then during the hearing, the arbitrators are sitting, physically next to each other. So there's a line of communication between them, and you often would see them, whispering between themselves. Similarly, during the breaks, they have a room which has got tea and coffee and biscuits, and they can discuss, the evidence that they have literally just heard. And the contrast to the virtual setting is quite stark. The arbitrators are quite isolated. They're sitting in, different places, but often different jurisdictions and time zones. And I think that means that it's much harder for them to keep that line of communication open. In one of the hearings I was in recently, it was quite clear that one of the co-arbitrators had things he wanted to say, maybe a question he wanted to ask, but because of, the problems with mute and people talking over each other, the chair just did not seem to realize that, and so things were left unsaid. So I think the key point is that there are some disadvantages to the virtual hearing which we must bear in mind in order to ensure that the quality of the evidence and the quality of the decision making and the participation of everybody is not negatively impacted. I'm now going to move on to opportunities, which is the next slide. So I identified four. The first one relates to technology. I feel like I've talked about technology a lot, but I think now, because of the pandemic, we have, as lawyers, at our disposal, very user-friendly technology. At the same time, we have all been forced to use it, so we all can use it. And at the same time, tribunals are now very comfortable with accepting evidence given by video as standard. So I think this is an exciting opportunity to use virtual hearings as a cost-effective, efficient, and flexible tool when it is appropriate to do so. Now, my second opportunity relates to collaboration. I've already talked about, the discrepancies in technology and the issues that could present. And I think this is a really, a unique opportunity for some of the bigger law firms to collaborate with their partners and to provide the technology and provide training if and where it is needed to ensure that we really do have equality of arms in this new post-pandemic world that we're living in and when we're having to attend virtual hearings. The third opportunity relates to diversity. I think the flexibility of the virtual hearing has the potential to make it a more inclusive process. So just as a personal example, during the pandemic, I was able to attend a hearing when I had a 5.5-month-old baby and was technically on maternity leave. The hearing was supposed to happen in India, and had it gone ahead in person, I would not have wanted to travel or leave my baby. But because it took place virtually, I was able to fully participate, not just in the hearing, but in all the preparation. And obviously childcare is just one reason why people may not be able to travel, but there are many reasons why. And I think there's another point, which is perhaps more of a question, is whether we will see the appointment of more diverse candidates on tribunals, as well as the instruction of a more diverse pool of expert witnesses. Now that we don't need to have in-person meetings all the way through the process. And the final opportunity relates to climate, which I know has been mentioned a lot, but I think one of the things we have learned during the pandemic is you can conduct an arbitration without printing a single piece of paper and without flying a single mile. Now, obviously, that isn't going to be the best use of time always, but I think that, really, I think it's not going to be acceptable to go back to the pre-pandemic conduct of having, huge teams of lawyers flying around the world, every week with 50 bundles of documents. So I think it's a really good opportunity for lots of the, the campaigns, the Campaign for Greener Arbitration and the Arbitration Pledge. So I think my concluding remark would be, I think there are some disadvantages to the virtual hearing, but I think there are some more exciting opportunities.
Thank you. Thank you very much, Flora. I'm sure we all have stories to share about our experiences during the pandemic and how things have changed. In fact, I was discussing with Julie earlier about other lessons to be learned. I want to ask two practical questions that I think will be relevant for the vast majority of the delegates today. There are many arbitrators, there are many early junior arbitrators, there are many people that will be looking for their first appointments as arbitrator. How do you think all this has affected choice of arbitrator?
So I think that it has affected the choice of arbitrator, and I think there are 2 points. The first point is that now, when parties are considering which arbitrator to appoint at the start of a case, there is a very real possibility that the hearing is going to take place virtually. And I've discussed some of the differences between the virtual and the in-person hearing. And I think when it comes to the role of the arbitrator, my experience has been, I think the arbitrator in an in-person hearing needs to be more engaged and more proactive in order to keep things to schedule, because often the schedule is much tighter in an in-person hearing. So I think you definitely want to consider candidates who are proactive and engaged, but also, and this might be an obvious point, they need to have a handle on technology. I think most people will, because we've all been forced to use it, but it's certainly a consideration. And, being very tech savvy is probably going to be, a positive. But one of the other things, one of the other points is that if you have a case where you really think as a lawyer that there should be an in-person hearing for whatever reason, maybe the credibility of the witness is very, very important, you need to consider appointing a tribunal that's going to be more likely to guarantee the in-person hearing. So you might want to look at, which arbitrators are flying around the world, attending conferences, and which arbitrators seem much more reluctant to do so. And I think over time you will see a trend developing and a preference developing, with some arbitrators feeling more comfortable with in-person and some virtual. But I think, in terms of, prospective arbitrators, I think, I think getting it known and out there that you're happy to travel around, you've got a handle on the technology, and that you're very proactive. I think those would be the points I would make.
Thanks. And just picking up on that, you've mentioned the increased likelihood of in-person arbitrations, and some arbitrators who might be more willing to go in person than virtual. Do parties, I think many lawyers would be interested to know whether parties have a right to an in-person hearing if they wanted it.
So there's been some research conducted actually into that very question of do parties have a right to a physical hearing in arbitration? And they conducted that research over, I think, about 78 countries. And what they found was that there is no express provision in any arbitral legislation that expressly allows or gives the right to the party to request a physical hearing. And the majority of researchers also concluded that there isn't an implied right either. And that's because really the discretion of the tribunal in organizing the hearing is very, very broad. So they have the discretion to either, to even order that no hearing should take place and it should be done and dealt with on the papers. So that wide discretion means that there isn't a right. And actually, one thing parties might consider if there was a strong preference to have an in-person hearing would be to maybe write that into the arbitration agreement at the outset.
Thanks. I'm going to ask each of you a question to end this, and I might ask the audience as well. And I want a simple yes/no answer. And it's just following on from Flora's response just now. Now, I know there are differences between preliminary hearings and cross-examination and all that, but as a general, do you prefer, I'll start with Flora, do you prefer in-person hearings, yes or no?
Yes.
Yes. Alistair, do you prefer in-person hearings?
Yes.
Bernd?
Yes.
Can I have by show of hands, do you prefer in-person hearings, by show of hands? So I think there's research, but then there's, there's this. I think we're going to end here, and I'll ask everyone to show applause, please, for my panelists. Are there any questions? Those are interesting. I see one. Oh, there are a few questions. Do we have time for? I see two questions. There's a gentleman in white at the end there. Yes.
Good afternoon. My name is John. I work with the Institute of Legal Practice and Development. My question goes to Flora. I would like to know whether in international arbitration in Europe, it is possible to base a challenge against an arbitral award on issues of technology, a challenge in court. And maybe before that, I should have asked, do you think issues of technology in electronic arbitrations call for greater judicial supervision of arbitration? Thank you.
Thank you. So to answer the first question, whether you can challenge an award because of problems with technology, I think it would obviously depend on what exactly had happened. Actually, one of the interesting things from the research I mentioned about whether you have a right to a physical hearing was that the conclusion was that it would be very difficult to bring a challenge to an award based on the fact that it was a remote hearing. But whether or not issues with technology would amount to something that would enable you to set aside the award, it seems quite unlikely, but it would really depend on what happened, because obviously, well, first of all, there are very limited grounds that you can challenge an award. Those vary from jurisdiction to jurisdiction, but it is very, very difficult to challenge an award. And I think I would be surprised if a tribunal had not been able to provide for and to kind of remedy any technological issues that would happen. In terms of greater judicial intervention on technology, I think this is maybe something, I mean, from my point of view, I have only seen like very small technological issues. So, somebody's battery running out or the Wi-Fi being a bit dodgy. I have not come across, issues that have really, really affected the hearing themselves.
Thanks, Laura. And of course, you're also entitled, I mean, this is forward-looking rather than when the dispute arises, but you're also entitled to specify how the hearings will be held. And you can say you want a venue X and in-person hearing if you want it. But you're right, and I think I'm aware of that case, one case where the English courts considered whether technology issues could form the basis for a challenge. And I think I only read a summary, but the view was that it would be very difficult, I think, to use that as a basis. Is that correct, Alistair?
Yeah, I agree with everything Flora and Gilles have said. I think the only argument would be, and obviously, as Flora said, the grounds for challenge vary from jurisdiction, but in many jurisdictions, like Rwanda, for example, essentially you've got to try and shoehorn anything into some sort of public policy type argument, and there's sort of a threat to judicial due process or arbitral due process or something like that. So you'd have to come up with some sort of basis of saying you were unable properly to put or present your case. But even then, if you had raised it before the tribunal, your concerns, and the tribunal had dismissed those concerns, having given them consideration, it'd be very difficult to conceive of a court, a supervising court, then setting aside an award on that basis, absent some really extreme circumstances. For example, if you had a key witness who couldn't connect, and the tribunal said, well, let's just go ahead with the arbitration without that evidence, but I would have thought, I can't imagine any serious tribunal making that sort of decision. Never say never, but.
Yes, never say never. We had one other question this side, yes? Lady at the back. There's a lady at the back. Yeah.
Thank you. My name is Florida Kawasinga. I'm from Rwanda. I manage a law firm here. I do a lot of arbitration. And I'm excited that one of you, at least on the panel, has been here 40 times. It's very exciting for me that you come that many times here. The reason why I'm making a comment is that I'm quite disappointed that I'm in the minority. I have absolutely enjoyed conducting arbitrations virtually. Let me say that the lady who spoke about this literally jumped over. I don't know whether it was your preference. You jumped over the advantages and went straight, and I think you corrupted all of us here. But the fact that we could access top-notch arbitrators sitting all over the world, for me, was very, very exciting. I'm sitting in my office with, at the law firm, and I can have access to, my other colleagues if I need something. I didn't have to physically go somewhere. And my client doesn't have to pay so much money for people to come in from London, to come in from other places. Is it a question that we are afraid of something new, of getting used to technology, of I did not see any disadvantage in me being online and talking to arbitrators sitting in Malaysia whose calendars are full for the entire year for arbitration. So getting that opportunity to represent clients through that means, it was absolutely exciting. The other thing that it's not just for arbitration. During the pandemic here in Rwanda, we were doing a lot, even court cases. The only concern I had was when it came to criminal matters. But when it comes to commercial and arbitration and all of that, I quite honestly would like to encourage everybody to try and move towards where the world is going, not to look back to be, in our comfort zone of what we've been doing, or for years. Please, let's redo the questionnaire. How many for virtual?
Okay, can I perhaps just add one supporting comment to that? In that, I mean, I did several remote arbitrations during the pandemic, including one where I was one of only 3 people staying in this hotel. It's basically the 3 of us and the chef and the receptionist, I think, from what I remember. But so, they have been effective. And I think the more remote arbitrations are done, the more some of the challenges that Flora identified can be addressed. So, for example, communication between the arbitrators, if it's possible to have some sort of side channel between them where they've got sort of WhatsApp or their own separate video or something like that, to try to replicate the immediacy that they would have in an in-person arbitration. I've also heard arbitrators and judges, in fact, say that they prefer that. I mean, they're in a minority, I think, but some of them said they prefer evaluating a witness who they're looking at on a screen, because typically you've actually got more of a close-up on their face. So when you're doing it across an arbitration room or across a courtroom, you can actually not necessarily see the finer details of the facial expression. Whereas when you're looking at somebody whose face is filling the screen and very close up, you can perhaps tell some more. Quite interesting. Some of the arbitrations I've done, actually, I tend to like looking at my opponent's faces. And when you've got the close-up, when the camera's fixed on, the counsellor who's on the screen, it's more difficult to be inscrutable than it necessarily would be, because you are there all the time. So I think there can be that advantage for trying to evaluate witnesses in particular. So let's see.
Yeah, I used to be old school in that when I needed to review a document properly, I had to print it out. And when I needed to think, I had to print it out. But because of the pandemic, and I'm sure I'm not the only one who has home printing issues, home printers hardly ever work, I've found. I learned, and I think I evolved to do my thinking on screen. So I think I agree with you that it could be a mindset thing, and over time, I know some have said they prefer for cross-examination to see the person. And of course, many of us want to be here in person, right? Rather than doing this remotely. So there's some benefits, but maybe over time, people would appreciate, the benefits of being able to examine, to assess a witness or even your opponents, as you said, out there on screen.
I was just going to add one more point, actually. I think that the reason that I prefer an in-person hearing is that human element. It's why it's so much nicer to all be here together in this room rather than all doing this at home from Zoom. And obviously, that doesn't go to the process of arbitration and the benefits and the disadvantages. But I think that's just that's from a personal perspective. That's why I prefer in person. But really, I was hoping that my presentation would show that, really the advantages do outweigh the disadvantages, and the disadvantages, they can be, you can take steps to address them.
Can we show our appreciation for our panelists, please? Thank you very much. Sure.
Can we again appreciate our panelists? From the program, we are running behind 1 hour. I think we're going to use only 1 hour for lunch. We'll be back here at 2. The lunch is served at the tent. Please, the business networking lunch will be served at the tents. There'll be ushers outside to guide us to the place where we're having our lunch. Thank you.
mine. And it's yours and it's mine. That's right. And at the end of the day, we should give thanks and praise to the one, to the one. Have I told you lately that I love you?
And I think that I'm very glad that this has been the topic that has been chosen, because I do think that there's a need to make sure that practitioners in the region are getting ahead of this trend, which is only going to accelerate. And so I hope that we have a lively discussion today. And I think we'll have a pretty good amount of time to ask questions of the panelists. And I think and get them from the floor. I'm very glad that this has been the topic that has been chosen, because I do think that there's a need to make sure that practitioners in the region. I could have just pre-recorded my session, had it played back. All right, so without much more from me, I would like to invite Professor Abbotzi, if you're still on, to please start the presentations. Thank you. Session.
So I will try and focus my presentation so as not to repeat what he had already said. I'll try and focus it on the S and the G. That is the social aspect and the governance aspect. So the whole essence of ESG really is to encourage companies to engage in sustainable development and sustainable investments. And so the S, which is the social component of that framework, really refers to four things, four key criteria. On the S and the G, that is the social aspect. The first social aspect is the labor practices and decent work. And then you have the human rights component. And human rights component here includes, child labor, discrimination. Then we have the society component. The society component here involves, involvement of the local communities. And I will discuss further how this context plays out in different areas of the continent. And then, of course, there's also the product health and safety aspect of it. When we come to the governance, as Louisa had mentioned, we are really looking at, what measures have private corporations put in place, to prevent corruption and bribery incidences. So let me just begin with the social aspect. When we look at the social aspect, some of the cases that have come to the fore in Africa touches on the social license. To what extent has the investor involved the community before engaging in the project? And we have good examples from Kenya. We actually have two cases. And the first case is the case of Laisami's constituency versus Lake Turkana Wind Power Limited. And in this case, what the community in Laisami's constituency complained about was that the private developer did not seek their consent before establishing the wind turbines. Because in establishing the wind turbines, the county government actually allocated them 150,000 acres of land to do so. So according to them, it was that the county government did not have the authority to allocate that land to this developer without their consent or without their involvement. So the court agreed with the community, and what the court noted was that the developer had to engage the community through the Trust Land Act provisions in terms of just finding in what ways can their grievances be redressed. Of course, a major component of that is compensation. And the court, what the court did was that it gave them a grace period to find a redress within 12 months' time, and if no redress is found, then the title deeds for the 150,000 acres would be cancelled, would be deemed cancelled. So the other case in Kenya as well is the case of Kinangop Wind Park project, where the developer faced a lot of resistance from the community. Because the community also felt that they had not been adequately involved before the project was initiated. So in the context of East Africa and Kenya, it normally boils down to land rights and use of land. And the thing that the developers have to bear in mind is that, the social context here is that some of this land is community-based land. So you have to engage the local community to a sufficient level, to a sufficient degree to be able to proceed with your project, notwithstanding that you may have obtained other licenses. It's the social aspect is important to consider. If we go down to South Africa, their kind of social license is different. It's more about transformation, taking into account their history, where during the apartheid government, the Black community was not engaged to sufficient levels in terms of economic empowerment. So the South African government came up with the broad-based Black empowerment economic regulations. And one of the investors, that is Foresti, sued the government in an investment based on alleged breach of an investment treaty, saying that at the time that it put up its mining companies, this regulation was not in place. And this regulation requires that, any investor has to give 26% of shareholding to the black community, and that in the context of South Africa is part of the social license, just to empower the local community. So they challenged this provision. They cited it as an act of expropriation. It was, however, later settled, so it didn't go all the way to conclusion. But it informed the South African government to review their BITs, and most of the bilateral investment treaties were cancelled. So, and I know that will be part of a discussion probably tomorrow about, how are the BITs taking care of sustainability issues. So the aspect of so far, those have been on the social aspect, those have been the sort of disputes that have emerged from the continent. When we come to the kind of trends that we are likely to see in the future, what I think that we are likely to see is we are likely to see that many of the businesses are likely to enter into, when we come to climate change, are likely to enter into mitigation contracts, mitigation and transition contracts, because as part of the requirements under the ESG, they have to mitigate their carbon emissions. So that is going to affect the whole value chain. And that means, the kind of operations that they have now to consider in what ways can we reduce our carbon emissions. So we are likely to see that, companies entering into specific climate change mitigation contracts for purposes of allocating that risk and for purposes of just allocating who bears, the responsibility in that contract. So in such scenario, you are likely to see disputes because, of course, a question may arise as to whether the party that is supposed to transition the operating system of a manufacturing company, for instance, to become more clean and more environmentally friendly, whether it has met the threshold. And if it hasn't met the threshold, then of course that leads to a dispute. So that I believe will probably be the next frontier as more and more companies adopt the ESG standards, and which is not far-fetched, because so far there are 4 African countries that have adopted the ESG guidelines for their listed companies. Kenya being one of them, Nigeria, Botswana, and Egypt have also adopted them. So because the listed companies would be required to disclose to what extent they've complied with their ESG requirements, then that of course will translate down to the value chain. The other likely frontier that we are going to see in Africa is shareholder disputes based on the disclosures that the listed companies have given. So if listed companies have made a disclosure that according to their operations, they have anti-bribery policies, that mitigate against corruption. And if that turns out to be false, then a shareholder could rightly take up a tort claim against the company for publishing a statement that was misleading and that led them to invest in the company. And if a corruption scandal arises and it transpires that it's because they did not have adequate systems, that could lead to a dispute. So that is an area that we are likely to see. So We also, of course, going to continue seeing suits by the non-governmental organizations, the activists, to force companies to be compliant with climate change requirements. We're also going to see them, continue to file suits to force companies to take care of the social aspect of the ESG, be it local content requirement or be it diversity in the leadership of those institutions. So that is going to continue to happen. I think the question for us is arbitration equipped to handle sustainability disputes? And I think we may need to think about it a little bit more. And one of the things that we have to take into account is that the disputes that arise from sustainability are not your ordinary, breach of contract or tort claims. So some of the things that we have to take into account is that when we provide an arbitration clause, for example, if it is a mitigation and transition climate change contract, it may be important to provide that the arbitrator should be a sustainability expert, because the dynamic nature of environment and climate change is that the parties would be comfortable in having their dispute be determined by an expert. The other aspect, I think, that arbitration may be attractive to litigants is there's the development of the Hague Rules on Business and Human Rights Arbitration, which was launched in 2019 at The Hague. And this is based on the ancestral rules of arbitration, specifically tailored to determine human rights abuses in the context of a business. So that may be attractive to disputes between local communities and investors. Instead of approaching the national courts, they can enter into a submission agreement where they agree to submit their dispute to an arbitration panel, and they have the flexibility of choosing, the arbitrators. They have the flexibility of choosing the rules that will determine this dispute. So not your ordinary tort rules. And of course, for the investor, there's the attractiveness of the proceeding being confidential. I think the other aspect that could probably make arbitration also attractive, in line with the flexibility, is also the ability to use non-conventional remedies. This is pursuant to the UN guiding principles on sustainability. So they have more flexibility than perhaps what a national court would have in terms of the kind of remedies that they would give if they adopt the UN guiding principles. And so I think arbitration would be, the future is bright for arbitration to be able to resolve the sustainability disputes. Yes, I think I'll end my presentation at that point. I do not want to touch on what Professor Kotsi is going to present on.
Thanks very much, Desmond. I understand that Professor Abotsi is back online. Professor, can you hear us now? Hi, Professor. Now oh, great, excellent. We're glad you're back, because actually your section of the presentation or today's session is very important. So please proceed.
Okay, so first of all, I am so sorry to everyone for the inconveniences you have to endure and having given me the opportunity of coming to the meeting virtually. So I would like to continue from where my colleague ended. On the standpoint of ESG, it's important for us to know that the Deloitte report indicated that of chief executives that were sampled, 80% of them said issues of the climate are important issue of business. If businesses operate in an environment in which they extract from the environment, in which they sell to people who are impacted, then it is a natural and logical consequence of things for us to accept that the environment, the consideration of the environment, are very important for ecosystem. Therefore, we live in a time where companies know more we want to profit, and the extent to which companies can maximize their own private interest. Or we live in a time where ESG operations have become materially important for the successes and future of companies. Some will therefore say that we have moved quickly from the era of private shareholder interest in profitability to what has been called stakeholder capital. In other words, companies are measuring the successes or failures of the operation by dynamics and metrics that that are different to apply ESG. It's important that companies understand this. So the old model under which the environment was treated as an externality in terms of something that should not really be the constraint company. The budgeting for companies' operation, the configurations of their various. In the past, the environment was considered as an externality. Today, companies are compelled to consider the environment an important mainstream component of the overall. What's the reason for this? That consumers are becoming sophisticated, and market participants are asking questions that formerly were not necessarily important to companies. And so the bag you're using, who you're wearing, the various raw materials that were used in the manufacturing of things, market participants, consumers, are beginning to ask whether these were sustainably exploited, whether these were exploited in a manner that impacts them. And so boards, for example, of fossil fuel companies are beginning to ask the hard of shifting their business models, knowing that the future is one which, in a way, from fossil fuel and the use of energy that impacts the environment. So the question as to whether company should consider ESG and traffic is no more an if issue, no more a contingent issue, but it's really an issue of how we go about it. So we move from the if, perhaps even we move from the when, but we have gotten to the point where we're asking the how. And it's important that companies consider ESG because ESG impacts profitability, not necessarily as an obstacle, but really as an inescapable dynamic. And as an inescapable dynamic, has to impact into the overall process. And so lawyers are going to have to honor the advice they proffer to their companies in terms of how contracts are, the extent to which the entire value must be reflected in the contracting process, the extent to which suppliers and other players in a company's overall business would have to be brought to the table to understand that ESG considerations material. And so, as I indicated, the new model for us to consider ESG, because the failure of that has serious reputational consequences. And how do lawyers advise their clients, lawyers advise companies, that in the contracting process, we have to ensure that we do not implement ESG. And here's what I suggest. particularly from the standpoint of arbitration. We can advise our clients and advise our companies to understand that failure incorporate ESG can actually result in serious cost, serious transactional costs to the entire business model or model companies. Litigation can have an impact in the extent to which companies are able to overall leverage on the contracting process to ensure ESG. Litigation can be costly. The reason it can be costly to companies that experience has shown that if these companies are trying to evade the process, or rather to evade the obstacles and individuals in the various areas of companies, I'm trying to avoid some of the difficulties of litigation by being a bit more dynamic. The issues of, say, justiciability, the issues of standing, other preliminary objections that are not being made by show up, in a court or in an arbitral body. Initiatives that are considered. So to avoid this, it's important that companies consider ESG not from the back-end perspective, i.e., you wait until there's a litigation brought against the company, but companies actually incorporate it in the front. And the way you incorporate it from the front end, incorporate or is to consider ESG things, in the whole contracting process. And so the extent to which company's operations are going to impact the environment, the extent to which the company is accused of taking unsustainable practices that can really impact the environment, impact governments. So the reputation, there are consequences and consequences in terms of the overall profitability because of its failure to that need. Now, that therefore leads to the question of how companies are structured and the extent to which, in reality, arbitration is more than just be considered as a theoretical position. But these can actually have real material impact on how companies are. Because the truth of the matter is that when companies are they are primarily driven by how to. So even though companies also the extent to which they impact the social dynamics of things, they are primarily differential. And this is where it becomes important that we do target shareholders in terms of the strategy, because it is the consensus of shareholders that guide the board's agenda. And it is how boards are impacted that management are also able to manipulate the board in terms of how they go about their various projects. And so I think from the street, the focus really has to be on shareholders. And the shareholders are convinced all will have the agenda in the manner that the satisfaction and management would also probably be enabled to undertake ESG, which is given that they do have the mandate from overall perspective. That then makes the work easier for lawyers. Because, like it or not, the truth of the matter, lawyers are fundamentally a group of professionals who take instruction. We act in that direction on the basis of the person beginning. And so, even if you have the best arguments, once your board, and in this case, your management, are not convinced, it becomes difficult to advise them. And overall, that fits into the contract process, which is moderated by lawyers. So I was advised to have 10 minutes. I think I'll rather limit my presentation to this, and be happy to questions and back once it's to the stage. So thank you very much, Lisa. My apologies for all the difficulties.
Thank you, Professor. We'll definitely come back to you with questions. Lawrence, the floor is yours.
Okay. Good afternoon, and thank you to the organizers for giving us this opportunity to speak to an issue that has become, as Professor has put it, no longer an externality, but a material question. I've been asked to run my thoughts on the question of tracking climate action. I'll give it from an institutional perspective. I will posit that with ESG, we are either complacent, complicit, or compliant. So the 3 C's: complacent, complicit, or compliant. I'll then look at, in a summary overview, the Green Arbitration Initiative. I'll delve into a continental practice perspective, looking at Africa. And then I hope to tie up with reinforcing tangible and actionable procedures. I know it's an afternoon, but I want us to engage in a bit of numbers. A report has it that in the last 40 years, paper usage has grown by 400%. And what does that mean in terms of trees? That 2 million trees are felled every day. Now mark, every day, 2 million trees are felled every day for global paper consumption. And this means that 4 billion trees are cut every year. Now note, 4 billion trees are cut every year to serve our paper needs, and that includes you and I in arbitration. Think of the one ream of paper that you use in your office. It has 500 sheets of paper. To make them, we consume 5% of the usable trunk material. So take a tree, 5% of what is usable to make paper, because not all of it is, goes to the 500 sheets of paper that are in your rim. It also says that a 45 feet tree produces 10,000 sheets. Now that may sound many, but if you reduce them to rims, they are mere 20 rims. Translate that into a typical arbitration, mid-size arbitration. Think about the number of papers that we use. And I'll start from the end, the award. Take a typical award of about 600 to 1,600 pages. Multiply by the number of arbitrators, likely 3. Multiply by the number of parties, the number of legal counsel. Multiply by the number of corporate advisors who will reproduce that award to speak to boards, and we could go on. Now that's just paper. We could speak about transportation end to end, from the time the tree is cut to the point of processing, packaging, and then logistics to your printer. I hope you see that when we speak about, especially the environmental pillar of ESG, we cannot afford to be complacent. In fact, by doing nothing, we are being complicit. The only option we have is to be compliant. And what does compliance entail and mean? Helpfully, in the year 2019, one of us, an arbitrator, Lucy Greenwood, was disturbed by this state of affairs. And she acted by coming up with what has come to be referred to as the Green Arbitration Initiative. The intention really is to seek to reduce the environmental impact of international arbitration. And by this, she started off rallying the arbitration community and came up with a promise in 2019 that strongly advocated for a significant reduction of the carbon footprint of the arbitration community. And here the main focus was especially with the amount of travel that are devoted to any one typical international arbitration case. When you put the arbitrators, the parties, the witnesses, and and the man-hours spent in preparing for cases. That conversation through a committee gave birth to the green protocols. And this really was a set of actionable points, tangible points, through which we as a community could contribute to reducing the carbon footprint. And there were three main integral behavioral patterns that were proposed. One is adapting cleaner forms of energy. A lot has been said about that before. It involves what we do in our offices, smart offices, smart lights, smart taps, and such simple things that we can do to contribute to cleaner forms of energy. The second part of it was reduction of and or elimination of long-haul travel. If she was here this morning, I'm sure she might have been disappointed. The vote was overwhelmingly for physical hearings. And then the third one was for waste minimization through elimination of hard copy filings. Real, tangible, actionable points which we in our fraternity can engage in to contribute to the reduction of the carbon footprint. That initiative has gone on to the Green Arbitration Pledge, whereby as individual arbitrators, firms engaged in arbitration, institutions like ourselves, who are arbitral institutions, also signing up to the pledge and thereby binding ourselves to a set of actionable things that we can do to contribute to the climate action framework. What were the main aspects of this protocol? One, switching to renewable sources of energy or fuel. I can imagine here being an institution, we do have geographical locations and offices, been very particular in selecting venues, not just A venues, but A venues that are green locations, utilizing processes that conserve resources and minimize pollution. And there are many ways in which our offices contribute to that. Adopting a carbon neutral stance or reducing carbon footprint. So an institution undertakes by a particular time to be a carbon neutral stance. And there are many ways in which this can be achieved and tracked, statistics kept and reported upon. And then of course, planet restoration, for example, through initiatives like tree planting. I think in the morning, the Minister of Justice did allude to this. As we return home, we take stock of the amount of emissions that have been produced by us traveling. And when we get home, we plant a tree or more. And then adapting clean energy initiatives. So that's the Green Arbitration Initiative. This, in some ways, has been given a boost. We have leapfrogged a bit in arbitration, especially because of the COVID period. So there were positive aspects that came about through the COVID period. So when we scan the continent of Africa in terms of practice and giving it perspective, the Africa Arbitration Academy led the pack in developing the virtual hearing protocol. And arising out of the protocol in 2020, a number of institutions adopted that protocol as a guideline for virtual hearings. Perhaps the thought behind this was merely to ensure that hearings proceed. But having looked at the Green Arbitration Initiative, this protocol itself fits well into the contribution of arbitral institutions and arbitration practice on the continent to reduce the carbon footprint. So institutions like Kigali here, ourselves in Nairobi, Cairo, and others in Lagos adapted this framework for encouraging parties to consider a virtual hearing in terms of international arbitration. So as it is, as institutions, many of us on the continent, at least the ones I've pointed out, have already adopted a protocol whereby we are exhorting parties, encouraging parties to prefer virtual as opposed to in-person hearings, apart from when it is very necessary. Then to the last point, reinforcing tangible and actionable procedures. Again, I'll give an illustration from a survey that was done by Herbert Smith. And they took that typical mid-sized arbitration. And from it, their conclusion was that for them to offset the carbon emissions from that typical mid-sized arbitration, they would require to plant 20,000 trees. To make it even more practical, they looked at forests in England, and they picked Hyde Park, about, for those who are familiar with it, 4 times the number of trees in Hyde Park would be required to be planted, grow, for them to offset the carbon emissions. What were the key components of this study? One, they looked at the earned hours, the amount of time spent in the office. They also looked at the travel in terms of CO2 emissions, including flights, taxis, all manner of travel that consumes fuel was added to this. In addition to that, CO2 emissions in terms of production materials. We talked about paper, the flash disks that you use, the chips that we have in our phones, on the computers. And in the end, a mid-size arbitration would require 20,000 trees to offset the carbon emissions. So of course, then we need to look at smart ways of contributing to reduction of the footprint of carbon. And one of the ways that has been proposed and which many arbitration institutions have picked up is smart arbitration. I know there will be a session looking at the technology, but thinking about smart arbitration in terms of online case management protocols, allowing parties not only to file, but also to share, write on documents that are communally or mutually filed, and having rules that facilitate end-to-end online case management, which many arbitration centers, including our own, are already onboarding towards, encouraging a model procedural order that takes into account the opportunity for virtual and online case management, and then of course, the perennial issue of the cybersecurity frameworks that support us to be able to operate on a virtual space or a hybrid virtual and physical space. I'll leave it there. I hope we shall have further conversation from this.
Thank you very much, Lawrence. So I'd like to go back to the professor, if he's still online. I think he took what is maybe considered a bit of a cynical view about the motives that drive corporate entities, or some people might think of it as a realistic view, and that is that until shareholders start putting pressure on management, things may not change. But Professor, I'd be curious to hear what can be done to shift thinking so that corporates see ESG as opportunities for profit making on the continent rather than as a liability or an obstacle to making profit.
Thank you very much. So I think 2 minutes. The first one is that how, and the second is the structure. The higher approach is the regulator. If we structure a regulatory in a various ways that compel operation with priority to ESG, operations good to ESG. So in the case of the market, if the action entity is supposed to submit an environmental impact, which many countries have, but it is made it stronger, more rigorous. Tell companies to meet higher standards and thresholds before licenses are issued, companies will complete internal mechanisms to ensure their environmental systems. That would also then lead gradually to a core project, because the dynamics of behavioral trends and then in fact, therefore the certain cultural shift just about beyond that, we can then have the soft. The soft one is to educate and mainstream ESG. Now the educator will have to be held in a box and the cynical view. If I'm a bit cynical, it's partly because of the past. Companies typically shareholders don't buy shares to make the ones, let's be honest. Shareholders buy because they want to have returns on investment. They want to the investment, the return investment that they make for this. So we can do is to ensure that we get getting shareholders on our side, that we get shareholders to understand the dangers and the costs of ignoring ESG. As I indicated, reputation. I mean, all of us will remember the story of income. When Volkswagen companies discovered that women have lied to the public, they have a sufficient investment in the operation, have been lying to the public, and they have actually in a manner that has negatively impacted on the public. Volkswagen, in 2 ways, they suffered serious reputation because the entire investment of the financing houses avoided Volkswagen because that the financing of the operations was actually affecting the environment, because we aligned the emission. But the serious commercial costs. The serious commercial costs that they paid billions of dollars to the United States regulators. And in addition to that, in terms of the sales, because we have the entire test system, they have to basically come to compliance. And those involve serious costs and financial costs. These are things that go beyond just regulation. Yeah, they have hard numbers, and these numbers undermine negatively on the company profitability. They should understand this. In terms of shipping the partner, they do it both the hard way and both together. And that difference.
Thank you, Professor. So it seems to me that your perspective is that in part we need a large stick and to make it very expensive to conduct your affairs in a way that has a negative impact from an ESG standpoint. And so I'm going to address a question to Desmond. I don't know if you'll be able to give a very clear answer now, because I do think it's debatable, but from the perspective of a private practitioner who probably acts for foreign investors in countries like Kenya, what is your view about the degree to which local enterprises or investors coming into countries in our region should be held to standards such as Volkswagen? There's the contrary view that developed countries have had decades of contaminating and violating human rights by having factories with child labor, etc. And now all of a sudden everyone needs to comply with these very high standards and needs to be brought before the courts and penalized for failing to meet these standards. Where do you fall on, where we should sit from the perspective of a region that is growing quickly and needs to continue to grow?
Okay. I think the answer to that is in two respects. Firstly, I think the reason why African countries should still adopt the ESG standards, notwithstanding that if you look at that their level of economic output is still growing and is not as advanced as the West, and they have not committed many violations, for instance, to the environment. I think it is important for African companies to still adopt the ESG standards because, one, if you look at the change in attitudes from the funders, the DFI institutions, they are looking to fund investments that are ESG compliant. So for a company looking to attract that kind of investment to partake in such kind of a project, it has to ensure that its operations are ESG compliant so that it can attract that kind of work. If you so that's from an economic perspective. Also from an economic perspective is changing consumer preferences. The more and more that the society is aware about the effects of climate change, and the evidence is obvious. I mean, if you look at when farmers are unable to plan because the weather patterns have changed drastically, then their preferences for the kind of products that they go for, they are likely to go for more environmentally friendly products. So it forces the business community also to comply with the ESG aspect. So there's an economic angle to it. The companies that comply the fastest or early win the economic race. The other aspect is actually the human element. If all the business, all the players in the business community comply with the ESG standards, then we win the human race because we will engage in development that is sustainable. We will engage in investments that will not only meet the needs of today, but we will have do not only profit the innovator, but also profit the local community. And in this aspect, I'm talking about things like, for instance, the Uber and the other taxi applications. I mean, there's been a lot of debate as to what about the rights of the drivers. I mean, the wages that they earn from this trips, is it enough to sustain their livelihoods? So I think if we take into consideration all those factors as a business community, then we will win the human race.
That's a very motivating speech, Desmond. Thank you. And I actually want to know that the most sustainable of all the speakers is actually Professor Abotsi, who didn't travel to Kigali today. So let's go from this very motivating speech to the depressing numbers that Lawrence quoted earlier. You made me smile when you were talking about the number of trees that we kill through our pleadings. And it reminded me of a previous panel session in which I participated. I think it was a question raised from the floor. It was organized by the Chartered Institute of Arbitrators in Kenya, where there was a comment about whether we should ask advocates to limit the number of pages that they actually file in their submissions. Do we really need to have, or are we smarter if we can write 400 pages worth of arguments than not? To what degree do we actually change the rules to limit the number of pages, for example, that can be submitted? So my question to you, Lawrence, from the perspective of the NCIA is, who do you think should be responsible for driving this sustainable change forward? To what degree are you actually enforcing some of these green initiatives, and to what degree are they just gentle suggestions to the people who rely on the center services?
Thank you, Louisa. I think at the heart of the matter, we as arbitral institutions are essentially entities. And so when jurisdictions are changing their laws to require entities, at least entities that operate within their jurisdiction, to be ESG compliant, we, by implication, are also required to be compliant with these undertakings. When I look at the arbitration space, we are in an ecosystem. So when you ask a question, who is responsible? We all are. The practitioner is, we, the arbitral institutions, are. And so we are enjoined to come up with frameworks that allow for us not to be complacent or deter us from complacency or being complicit, but actually operating within compliance. What are we doing? I mentioned that, at least in the case of Nairobi, and I know the other centers have done so, we adapted the virtual hearing guidelines. And this is one contribution towards enabling virtual remote hearings. The hope here being that as we promote the use of the virtual space, less and less travel will be necessary. As we also facilitate smart arbitration, by this I mean allowing for parties to be able to file, to share, to act on documents, all on one platform as opposed to printing, then in that way we can lessen the carbon footprint. What are we doing in actual fact? So yes, I agree. It is not just merely signing up to the pledge, but investing in, especially from the point of view of institutions like the one in Nairobi, transitioning to another 5-year plan, strategic plan, we have laid a heavy emphasis on digitalization, not just filing, but the entire end-to-end process, enabling parties to be able to file, to share, to act upon, up to the point of award, all online. Now, of course, in terms of the savings to parties, I do not see it as a question of offering. I'm sure most parties will be willing to take up proceedings in this nature. Already in the continent, there are conversations about the costs of arbitration. So this should be, of course, a selling point. The other one is, of course, integrating online case management protocols or rules. And of course, having the vantage point of being able to influence as thought leaders, educating, creating awareness in a small way. And eventually, once we start reporting, not just reporting on the number of cases, but also adding to it, reporting on our contribution to climate action. So I think in these ways, we shall be able to contribute to the need to address the carbon print.
Thanks, Lawrence. And I agree that everyone should take responsibility. If anyone has been to our offices at ANK in Nairobi, you'll see that there is no longer single-use plastic. We don't actually give printed materials anymore at conferences. We use QR code on people's phones to access the agendas. We try to not use ACs and so forth, and hopefully create a culture change that way. It's painful at first, and then it just becomes a habit. So before I open it to the floor, I have many more questions for the panel, but I think we're going to run out of time. I have one final question. I'll address it to a professor, but actually I'd like Lawrence and Desmond to also comment, if you have any comments, which is how can we leverage arbitration on the continent, whether it's between private actors or involving states, how can we leverage it to promote ESG on the continent? Professor?
Very much. I think arbitration can, the first one is for us to ensure that arbitrators themselves have an advantage. Those are the first one. Second one is for us to get sense of cost in the arbitration and litigation. So the first one is to get a sense of arbitrators who are alive. In many nations, develop principles that ensures that you have a clear alignment between societal expectations and the legal principles. Legal principles that are espoused by arbitrators. A few cases, the legal that are espoused by arbitrators actually evince an understanding of ESG. That situation in which contracts negatively impact and there are no consequences. And so under international law, for instance, the principle of what is called erga omnes, which is and no and that are higher than even treaties, higher than national laws. And these will bind parties, whether or not they are parties, whether or not they are. These principles put an hand in the hierarchy of law. Arbitrators must come to that recognition. Where ESG may be big level as the rules of erga omnes, with higher norms over and above contracting parties. Now, if I have these things, I think that will apply to the business and contracts and the contractual issues that we have, and then it's trumped by ESG rules, even where parties do not incorporate this. So that's the first one. The second time, I'll make it very quickly. But the second one has to do with the issue of optimizing the system of arbitration. Again, or optimizing the cost of litigation dependent on ESG. If companies understand that a failure to receive rule, a failure to incorporate the rules can lead to serious with their suit or consequences and arbitration or comment, and therefore they may lose a lot. Many things will be compelled to take into account ESG. In other words, we have an incentive, understand incentives. What are the incentives for us to what are the cost benefit elements? Do the cost balance negative against the benefit, and therefore it doesn't make sense for understand that these costs always negatively if they take this into account. Companies will align the operations under the years. So, and have a significant take account of it. In this case, I've been able first one in understanding of this and how we got second one, they will recognize the effect of cost effects of not to incorporate this. How these can then result of losses and serious event.
Thank you. I think that the connection is degrading a little bit. Desmond, Lawrence, do you have any comments?
Yeah, Prof has elaborated, dealt with it, but I could just add the special features of arbitration and make it amenable to respond to cases of ESG nature, and especially where public interest is pursued. By its very nature, normally there'll be multiple parties. Arbitration has already gone ahead in embracing consolidation and joinder, ways in which we can bring the many parties into one forum in itself lessens costs, makes it neater and easier to build precedent. But at the same time, if you look at the net effect in terms of climate action, it helps us conserve the man hours, the wastage that would go into separate proceedings that would be involved in, especially where there are multiple parties. So there are ways in which arbitration can contribute. As it is in the morning, it was mentioned already substantively, 133 or so cases. So other than just the substance of the case, the peculiar nature of public interest litigation itself actually rends itself more amenable to arbitration than your typical litigation.
Thank you, Desmond.
Yes, I think maybe probably what I would just add to that is, I think for arbitrators and those in the arbitration space, I think it is time to upskill ourselves in these sustainability principles, so that when this public interest litigation matters that would ordinarily be resolved by the courts, the parties opt to refer it to arbitration, then we have the requisite understanding of how to resolve the dispute. So I think that's what I would add. Yeah.
Thank you. Now I'd like to open it to questions from the floor. Does anyone have any questions? Yes, Duncan. Is there a microphone? Well, you have a loud booming voice, so you might be able to do away with it.
I can try to speak loud.
We can hear you.
I'll keep the question short. It's about the intersection between ESG and arbitration practice and law itself. It concerns the finality of arbitration awards and the G in ESG relating to corruption and bribery. What sometimes happens is an arbitration award is made and later evidence comes out regarding corruption and bribery predating the arbitration. Does anyone on the panel think, thank you, that the total finality of arbitration awards, sometimes excluding even the reopening of them in order to allow in evidence of prior corruption and bribery, could be a missed opportunity in arbitration to promote good governance by denying the beneficiary of an arbitration award those fruits if it turns out they have previously engaged in some corrupt practice which is contrary to the governance which we would like to promote according to the pursuit of ESG. It's a difficult question, but it perhaps cuts against the policy that most courts pursue and most arbitration lawyers espouse of absolute finality of awards.
Thanks, Duncan. I see you're going straight into the controversial topics. It's a very good question. I'd like to address it myself quickly, and then I think, Desmond, this is probably for you. Well, first of all, the absolute finality of arbitral awards is not the case everywhere. In Kenya, we've had a convoluted position on finality and what you can appeal and what you cannot. It is something that, at least from the perspective of private practitioners, is top of mind. And when we are advising clients who seek to invest in the country or enter into shareholder agreements and other corporate agreements, the question is whether we advise them to have a domestic arbitration clause or whether we advise them to have an arbitration seated elsewhere, which ideally we wouldn't want to do, or if it's going to be local, whether we would rather have them go before the High Court, because then you can appeal that decision. And it is something that we wish we didn't have to think about, and we wish we didn't have to or feel obligated to raise with clients in terms of the risk. Oftentimes, I think I would say that for certain types of arbitration or disputes, if resolved locally, we would feel a little bit less worried if we could go before the High Court than before an arbitral panel that might be compromised. I do agree that this is something that should be considered, but the main is that, and here I'm speaking from the perspective of the forensics and investigations front, it's very difficult to prove bribery, corruption, fraud, undue influence. When you can, perhaps that is something that should be allowed to reopen an award. But I think that it's the type of risks that probably needs to be mitigated well before we get there. And it includes efforts in terms of training and oversight by arbitral institutions, and just cultural changes. Desmond, Lawrence, I don't know if you have any views on this.
Yeah, that's an interesting question. And I think it would be, because most of the cases that we have seen involving corruption in arbitration matters, you find that, the arbitral tribunals would, rule that they do not have jurisdiction, for instance, to determine if it's an investment treaty dispute and the investor engaged in corruption to obtain whatever approvals it obtained. A case in point is the Kotek mining case, and I can see Senior Counsel Kamau Karori in the room. He'll probably expound more on that because he handled the case. But where a decision has already been rendered, probably we may have to do some legal gymnastics, maybe say there was some unjust enrichment, and probably it's a new cause of action because they have benefited from an award, yet the underlying contract corruption involved. So there's no easy answer to it. Perhaps another thing we may need to consider is, do we need to rethink our arbitration rules to expand the grounds for setting aside an award? Perhaps we may need to include setting aside an award on the grounds of probably corruption or bribery. So I think that's food for thought.
Yeah, speaking to the question from the perspective of an institution, I think what it re-emphasizes is the primacy of and the place of arbitral institutions in the entire ecology of arbitration. I believe the more and more we have an eye, the more and more we allow for scrutiny, which are inbuilt in administered arbitration, we will be able in many ways to alleviate the challenges that are common in ad hoc based arbitrations. And so yes, in terms of the governance, and especially speaking to the question of corruption, we will have cases coming into arbitration that have corruption as one of the issues, but when they enter into the arbitration space, we should be able then to, through pursuit of the G and the ESG, especially as arbitral institutions, practitioners, ensure by our own inbuilt mechanisms, we are not allowing out of the system awards which could potentially be challenged purely on the question of corruption in the arbitration process itself. And so I would see a future where the more and more arbitration institutions are taking central stage in Africa, this may become less and less of a problem, if at all. I'm sure jurisdictions are different, even on the continent itself.
Thank you. Any other questions? Back there. I don't know who has a mic.
Good evening.
Good evening.
My name is Christine Gibson. I work for the National Environment Tribunal in Kenya. And I have a question as well as a comment. I will start with a question. I had one of the panels, I think it's Desmond, that is saying that he sort of advises companies to deal with the issue of ESG standards and compliance for the issue of looking at gaining the economic race and the human race. But I ask this question, then who looks after the environment? Because as arbitrators or as those companies that we are representing or being represented by parties, we are operating on the environment. And every day you will agree with me that the environment is being degraded, and restoration or even the mitigation factors that are being done by companies are at the best minimum. So beyond the compliance to get this funding, to get this compliance with whatever is required at the initial stages, is there commitment, like the way we have seen what Lawrence said about one arbitration leading to 20,000 trees that have gone down the drain? Are there commitments to ensure that companies or even arbitrators or even ourselves here, we can go back home and plant trees for the sake of the environment, for the sake of sustaining the environment, sustaining ourselves and even the generations to come? Then on the comment, recently I attended conference of parties, what we call COP15 in Cote d'Ivoire, and it's a conference mainly about government giving commitments to take measures to look at the issue of the climate change and climate action plans that they will take as a country. And one of the commitments that was done there was to make sure when we go back to our respective countries, we encourage business people and all professionals to at least plant trees and cover crops that can look at the issue of the soil, can look at the issue of water pollution, soil pollution, and even combat the certification and the increased drought that we have seen around the world, and also the issue of looking at how we can make even businesses thrive, because we are looking at the environment. Thank you.
Okay, thank you, Christine. Yes, so I agree with you that there has to be somebody who looks after the environment, apart from just looking at the economic advantage in applying with the ESG. It is, of course, important to look after the environment. And the national governments will still continue to play a big role in this. There has to be enhanced regulation in this area. If you look at the cases, for example, that were highlighted this morning by our keynote speaker, where NGO activists bringing up cases challenging the environmental impact assessment approvals that had been given, that did not take into account specifically climate change impact. And if you look at how the tribunals handled those issues, was that they went beyond what was provided by the National Environmental and Management Act, and said that even though those provisions do not provide specifically for climate change is a reality. And therefore, in complying with that new reality, then they made an order that the parties that were before them, the investor had to resubmit an environmental impact assessment form, specifically outlining what are the mitigation measures that they'll put in force. So government will still play a key role in looking after the environment. I think the industries can also play a key role, and the industries, if you look at, for example, the banking sector in Kenya, they have come up with guidelines to guide the industry as to what commitments are they going to make towards reducing their carbon emissions. So the industries will play a leading role. So probably as the arbitration fraternity, we should, and I know Lawrence is here, he will speak to that, and he's already spoken to that, in terms of the role that they are playing in guiding arbitration practitioners on how to comply with climate change, their climate change commitments. So at industry level, I think would have a lot of impact in the business community. And I think also, if you look at just to touch on, like, you know, what kind of commitments have already been made. The various industries are alive to the COP26 commitments that various governments have committed to, and they are adopting that in various forms. In the construction industry, the conversation is still ongoing, but there are a lot of efforts in coming up with standards to reduce carbon emissions, because of course construction is a huge player or a huge emitter of carbon into the environment. So national level and industry level, I think I'll leave it at that. I hope I've answered your question. Thank you.
Thank you. I can see there's one more question, but I think we may have run out of time. Yeah, I'm seeing a big no from Agnes. Apologies, but feel free to approach the speakers later and we can have a heated debate on these issues. Thank you very much to the speakers. Thank you, Professor. Thank you, Lawrence. Thank you, Desmond, for a very lively discussion.
Incredible session. Thank you, Lawrence, Desmond, and Professor Abotsi for dialing in from Ghana. I'm going to suggest one thing, perhaps because we're running way behind. I'm going to suggest we take 5 minutes tea break, and promise it's going to be 5 minutes before we come back for a very interesting panel, the GC Fireside Chat. So if I can kindly ask you to quickly grab your coffees and come back inside so that we can carry on with the program. Kindly, thank you. Not networking, we can network later because we have drink reception from 6:30. We are lucky, so we can use that time to network. So quick coffees and come back, stretch, and we go to the next session. Thank you. Welcome back, everyone. Thank you very much for adhering to the 5 minutes. If we can please take our seats. Julie, if we can please take our seats. So we can start the next panel discussion. It's my great honor to welcome the next session. This is Fireside Chat, Perspectives from General Counsel on Arbitration. This is going to be moderated by Kamal Shah, who requires no introduction if you've been to EAC before, but just allow me to just mention a few things about Kamal briefly. Kamal is very modest. He's the head of Stevenson Harwood's Africa and India Group. He specializes in complex cross-border international arbitration, litigation, fraud, and asset recovery. He acts for governments, government entities, banks, private corporations, and high net worth individuals. You must introduce me to some of those, Kamal. He is highly ranked in the legal directories, chambers and partners, the Legal 500, and the IFLR 1000. He has also been named as a leading practitioner in Who is Who Legal Future Leaders 2017 to 2021. He's currently the president of LCIA, Africa Users Council, and LCIA court member. Kamal also sits as a board member for the East Africa Association. Also, I must take this opportunity to thank Kamal and his firm, Jide, for being a platinum sponsor and for continually supporting EAC. Kamal, over to you.
Thank you, Agnes. Welcome back, everyone, to a very interesting chat with an incredible panel of in-house and general counsel. I hope we can keep it very interactive. If you have any burning questions, please raise your hand and ask your question rather than waiting till the end. Agnes has done an introduction to me. I won't add anything more to it except to say that I was born and raised in Kenya, and I know there's many, many Kenyans in the room today. So I just wanted to thank EAC. This is the 9th year. They've been going on for a decade, and the fabulous 4 who started it are still together and have required no mediation or arbitration to resolve any of their differences. Leyu, Agnes, Elodie, and Wairimu. Wairimu is stuck in Nairobi, but well done to you, and I think you deserve a very big round of applause. So let me get straight into introducing my panel very briefly, and then we will talk a little bit more about their careers and their journeys and their institutions and how they bring the concept of arbitration together. It is a very diverse panel, and I think we will have an interesting discussion. So first up, we have Muna El Tayeb, head of legal at Al Jazeera Jordanian Bank from Khartoum, somewhere where I have never been, and I really hope to visit Muna. We then have Nada Amer, General Counsel, a Business Integrity Officer, and Executive Board Member of Unilever Mashrek in Cairo, a city I've been to many times as we discussed, and I hope to visit you in Cairo at some point. We have a replacement for Wairimu Karanja, who couldn't make it. Wairimu is one of the fabulous 4, head of legal at Persistent Energy. She's stuck closing a very large transaction. We have as her replacement a fantastic alternative from our neighboring country, Uganda, Barbara Nabueke, who is head of contracts and negotiations at the Uganda National Oil Company in Kampala, and again, a city where I've been many, many times. What I'm going to do is I'm not going to read out in detail their bios. They are very illustrious. All 3 women are very illustrious. I'm going to ask them to tell us in their words their journeys, which will be far more interesting than me sitting here reading it out. So what I would like to do is to talk about your careers and your organizations. I would like to then touch on your experiences of arbitration, the challenges and the solutions you have found, your attitude to mediation in the context of arbitration. And I want to then talk about what you think about when you look to instruct so many lawyers like all of us in the audience, what it is that really impresses you, what it is that really annoys you. And I hope you're honest about that, because there are many of us who would love to act for your corporations. And lastly, but probably the most important, is the issue of diversity, both gender and racial. And I'd love to know your views. We have a fairly good balance of gender in the audience, and I'm privileged to host an all-female panel. So I'm really looking forward to the discussion. I'm going to go and sit there rather than stand here, so we can chat a bit more. So, ladies, let's start with your career journeys and a little bit about your organizations. I know a little bit about some of you, but not as much as I'd like to. So perhaps we start with Nada to my extreme right. Can you start by telling us a little bit about Unilever? We know you make great ice cream, Ben & Jerry's, for those of you who have tried it, but I think there's a lot more we need to know, and your incredible journey. I think you've been there almost 2 decades in lots of different roles. So please, over to you, and then we'll work our way towards me. It's not, that mic is not working.
So yeah, but before I start with introduction, let me thank the organizers for the invitation. It's really good to connect with this wide spectrum of prestigious lawyers, and I have seen non-lawyers as well. It's really good to connect, and it's healthy after the long time. So thank you for that, for the invitation. So yeah, you've said, Kamal, I'm a GC and Business Integrity Officer at Unilever. And speaking about Unilever, it's one of the largest fast-moving consumer goods companies across the globe. We have around 400 brands that is sitting at everyone's house. So you name it, it's, as you said, Ben Jerry, Domestos, Cif, Lipton, Dove. It's going to take some time to name them all. So they're quite plenty. And the thing about Unilever brands is that they are purposeful. They are purpose-led. So they help us achieve Unilever purpose about creating sustainable common living place for our consumers. And just to give a bit of numbers to show the magnitude of Unilever, so as per the last statistics, we have almost 3.5 billion consumer using Unilever products daily across 160 countries across the world. So that's about Unilever. Moving to myself, I've been with Unilever since my graduation, so that's almost 18 years. Now you can do the numbers, do the math. Don't know how old I am. So it's a quite long journey. I've moved all the way up on the legal organization. It's been, and I have been expanding vertically on different geographies and as well horizontally, getting in more specified areas like competition, data privacy, intellectual property. So it was never boring with Unilever. It's been always challenging, and Unilever is so good at unleash your potentials. So that's it about me and about the company.
Thank you. That's fascinating. So 3.5 billion people on the planet use your products. That's half.
I always get surprised with the number.
Excellent.
So that's true.
I'm sure most of the room does.
Yeah.
Can we touch on your journey with, and before that, because you've had interest in both academia and the criminal and the civil side as well, which I find fascinating. Tell us in your words how you achieved what you have.
Good afternoon, everybody, and I would like to thank also the organizer for this very good organizations. Very good organizing this event. For us, I'm coming from Sudan, Khartoum. My institution is Sudanese Jordanian Bank. This is mixed capital between Sudan and Jordan. The shareholder is from Sudan as well from Jordan. We have many branches, all of them in Sudan, like 17 branches. All of them, we working in as a bank, financial work. We have, as almost of the company all over the world now hiring in-house lawyers. We are working as in-house lawyer for all those branches. We have one central office, legal office, but we are not delivering all, providing some legal and non-legal. We're providing legal and non-legal also work for the company. We assist the company in the investment work as well. We have the inside lawyer. We have to have a lot of knowledge or huge knowledge about the investment itself, about the legal aspects. As well, we are trying to help the company in many aspects. We have to collaborate and coordinate with different departments of the company. So like human resources, we have to protect the intellectual property of the company. We have to work for all this consulting with those parties, with this department, so they can avoid violating law. As well, they can compliance with regulation from statutory bodies, official bodies. We are helping company to be in compliance with laws as well as official regulations. This is our role as in-house lawyers. We are extending about also we are when we are drafting contract. We should be engaged in these contracts. We have key role. We have key role in drafting the contract of the company, of the bank, because we have to put or to incorporate in our contracts. We have to incorporate suitable dispute resolution. So sometimes we need to negotiate with two parties of the contract as well. This negotiation to convince the parties sometimes to choose arbitration as one of the mechanisms to settle for the settlement of the dispute. And if they agree to go for the arbitration, we have as in-house lawyer, we have to work and be very careful at this stage, because this stage is very important. We need to put very specific clause for the settlement. If we go for the arbitration, we have to determine if this arbitration will be ad hoc or will be institutional arbitration. Also, we have to determine the law governing the arbitration, the location, the language, number of arbitrators. All these things the in-house lawyer play a key role in this stage, as we need the in-house lawyer to be with good knowledge, so he can do this work, because this will avoid the parties in any obstacles or problems, and go to the arbitration in effective and efficient manner, I think.
Thank you. I have many questions. I'll come back to you on that,
okay,
including what language you use. But let me go to Barbara. Barbara, you've been at UNOC for a while. You've been involved in some very recent big developments, including the financial close. And can you tell us a bit about what you've done and your journey as well?
Thank you, Kamal, and thank you to the organizers. I think I was introduced already. I am Barbara Daisy-Nabweke, the head of contracts and negotiations at Uganda National Oil Company. I think I'll speak to the company first before I speak about myself. And I'll take a few minutes because we are a very young company, and we really, every time we get an opportunity to come out here, we really want to speak about what we do and what we tend to achieve. In terms of Uganda National Oil Company, we have about 7 projects we are involved in, and all of them are really capital intensive. I'll start off with the Tilenga and the Kingfisher projects. which many of you are probably well acquainted with. Those are the upstream projects that are already ongoing and for which the final investment decision was taken in February 2012. Those two projects, we are looking at having about 34 well pads during development and also having about 340 wells drilled in that area. So that speaks to the magnitude of that project. That upstream project, I think the capex is about $8 billion. And then because everybody has spoken about the depleting of the resources will go away. We don't want to have infrastructure that is going to be a white elephant. So we are also participating in the space of discovering and exploring for more resources. So we also have a project to do with new ventures where we are looking to new licenses and participating in new licensing grounds as they announce and also probably submitting direct applications. We are negotiating today with the Ministry of Energy for a new production sharing agreement for one of the licensed areas still in the Albertine Graben. We intend, when you look at our mandate as set out in the law, in the future, we intend to go out of Uganda and try to get some acreage out of Uganda where we think the oil resources are. But that is basically in the future, but that will still be under our new ventures project. In addition to the new ventures project, when you move down the value chain, we also have the midstream, we participate there. And in terms of the midstream, there is a refinery that is intended to be about $3.5 billion. That's the capex that is intended to be injected in that project. Where we are at today, the engineering designs were completed and we are doing further studies to understand the project and also to source for the funding for that particular project. That project will also have a white product pipeline that will be moving into where we're going to set up a storage terminal, and that's where the products from the refinery will be received. There will be a terminal there. In addition to that, this morning, we spoke a lot about the crude oil pipeline, the East African crude oil pipeline, which we call the EACOP, which runs from Hoima to Chengolai in Tanga, Tanzania. And that particular project is also projected to carry about $5 billion. We are out in the market for project financing. It's intended to be 70-30. That's the debt equity ratio that we are looking at. In addition to that project, we have what they call the Kabale Industrial Park. If we are going to be refining, there is a lot of feedstock that will be coming out of the refinery. And with that, we also need to look at auxiliary industries that will be coming out of that. So we're going to set up an industrial park, and we are looking at all of you to express interest in taking some space, all your clients being interested in taking some space in Kabale Industrial Park, because we're going to have numerous industries there, and definitely your good contacts to guide us on some of the people who will be coming to us, because some of your clients are eligible to set up factories there and set up industries there, and also to participate probably in agro-processing. To facilitate that particular project, there is also a second airport that is being set up near Kabale Industrial Park. We are at about 70% progress on that particular project. So significant progress has been made. By the time the Kabale Industrial Park is in place, the airport will be running, and it's also going to support to reduce on the logistical challenges that we have on transporting, because we are really a landlocked country. Transporting logistics, transporting materials through Kisumu or Dar es Salaam is going to be a lengthy journey. So part of the cargo will be landing directly where the project is, and that way we shall be reducing on the impact of the project on the communities that live in that area. When you think about the number of vehicles that can be moving through that area at the peak of development. In terms of our other projects, we also participate in the downstream, where we have the Ginger Storage Terminal. This is a very small terminal. It was set up in 1970 and was passed on to Uganda National Oil Company to manage. It's about just 30 million liters when the tanks are full, but we are also looking to set up another storage terminal, which is the Kampala Storage Terminal. We are looking for joint venture. We are out in the market to look for a joint venture with whom to develop this particular project with. And that project also is going to be supporting our neighboring countries, because we intend to export the products and reduce also on the logistical pressure that comes onto our roads for transporting fuel through our country. In the nutshell, that's basically what Uganda National Oil Company does. Probably if I've left out one project, it's bulk trading. We also do bulk trading. We are importing white products and selling selling to the bigger customers, OMCs, so they can be able to sell out to the markets. We don't own any petrol stations. We don't sell to individuals, but rather we are targeting the oil marketing companies themselves. So we sell to people who are purchasing in bulk. So in a nutshell, that's what Uganda National Oil Company does. We are a young company, but very ambitious in terms of what we are targeting to do and what we are targeting to achieve. And I think listening to the capex that is intended for all these projects is enormous. For example, the KST project, you're looking at about 300 million being invested, 19 million, I think, in the Kabale Industrial Park, $8 billion when you look at the upstream. So the numbers are really significant. And I think we need the positive minds to sell these projects out there to people who are willing to finance these particular projects. In terms of Barbara herself, yes, I am a lawyer by training, and I started my career in a small law firm and moved on quickly to Standard Chartered Bank. I think the former general counsel of Standard Bank, who was my boss and who trained me, she's in this particular room. I was surprised to see her here. Emily, if you can wave other people. So I moved on from Standard Bank in 2012 and joined Talo, and later on moved on to Uganda National Oil Company. So my experience ranges from private companies to multinationals and also to the public sector, where I'm now working with government. In the nutshell, that's me.
You seem to have been pretty busy. It's great to hear such a young company with such big ambitions. And I think it's also going to give our West African colleagues a run for their money. Of course, the oil industry in Nigeria is very well developed, Ghana the same, and in Egypt. So it's about time we do accelerate our ambitions in East Africa. I will come back to you, Barbara, on that. Can I now just turn to your individual challenges and how you navigate these challenges in the context of arbitrations that your company faces, and has the role of arbitration increased in recent times compared to litigation? I'd love to know your thoughts, because we have three very diverse industries. You got energy, mainly oil. We have banking and finance, and we've got FMCG and personal care products. Perhaps, Nada, I can start with you in terms of your thoughts, please.
So yeah, definitely the arbitration has increased recently. So it's the most effective alternative dispute resolution. No one can deny this fact. So nowadays, with international cases where we have parties cannot agree on the proper jurisdiction, they go for arbitration. But the thing here is that as in-house lawyers, as we go in the decision-making process of recourse to the arbitration support system and deviating from the traditional court system, we have to be very much conscious and mindful to, and you've mentioned that, Mona, to the arbitration rules and clauses and provisions in the agreement, because, and I'm going to admit this fact, we're very much focused on the commercial terms and conditions, and we just choose arbitration and we go with the very standard provisions subject to ICC and blah, blah, blah. Just a few lines on that. No, that's a very tricky point, and here we're trapping ourselves. So we have to be mindful to those rules. And there are several issues and concerns that have to be largely addressed ahead in the agreement. And more specifications, of course, on the number of arbitrators, the venue, the language, and a lot of other arbitration elements has to be very consciously and as well very consciously drafted and in fit with the nature of the agreement. So that's one of the things that I start to be very conscious too. So it's not a kind of standard clause that we put, and it's not a one size fit clause in every contract. That shouldn't be the case. So that when it comes to the decision-making process, and as we go in the arbitration proceedings, definitely there are a lot of challenges, and I think everyone around here would be agreeing in different degree, of course. But one of the top things is that we cannot appeal the arbiter award, and that's so painful. The fact that you could see that there are incorrect features or legal deficiencies in the arbitration award, and you cannot recourse from it because of the binding nature of the award. So basically, this definitely make the consequences of arbitration more profound and more challenging. So that's, and if you would ask me, Kamal, how we would navigate around such, is unfortunately, I'm going to say it, is just have the appetite of acceptance. But of course, it comes in our calculation as we do the mathematics, as we say, okay, we're going to go with this challenge because there are other benefits that outweigh such. So another challenge is the discretion of the arbitrator. As he issued the arbitrator a word and there is no, it happens. And I have seen that in Palestine. They do not make it in writing, or they do not provide an explanatory statement. So actually it shows lack of transparency in the decision-making process and bias in the arbitration proceedings. So this is definitely very much, I would say, a very much disliked feature in the arbitration. Let me add one more challenge, and definitely my friends here would be adding further, or you'd be agreeing on what I have mentioned, is the enforcement. You're super happy you're done with the arbitration proceedings and you have this nice piece of a word, but you cannot enforce it. That's a trap. Because of the local legislations, because of these constraints that are put under the local laws. So it's very painful that you cannot get this arbitrary award in the execution mode. But again, by the end of the day, so we have to choose our battle correct. So if you want to go with arbitration, we have to weigh those challenges. And as we say, yes, we're going to go, definitely the benefits of the arbitration has to outweigh the challenges. And as we go, we have to be, we do have a homework still, which is to try to reduce the weight of those challenges, their impact. So this is kind of skill that we have to maintain all the way throughout the arbitration proceedings. I don't want to take much long. I know there's a lot to mention on that. So I will stop here.
I have two questions on the clauses you mentioned. Often we use very simple arbitration clauses. We cut and paste in a few lines. Have you developed your own detailed arbitration clauses? Do you tailor make them for every contract?
So yes, we do have a standard format for such, but again, this could be subject to customization and further tailor, depending on, again, as I said, some elements of the agreement. Let me give you one of the examples here. So if the venue of the arbitration would be in a country that is very politically driven country, I'm not going to go for one arbitrator. I'm going to go for three, so that I would avoid the political bias by the arbitrator, for instance. So yes, we do have a standard, but again, it's not one size fits arbitration clause that would fit in all contracts. There is a room for customization, and we have to be mindful towards that.
That's music to my ears, and I'm sure many in the audience. I have a question. Do you do that in-house, or do you go to external counsel for help on tailor making?
That's the second point that I would say I used to get trapped in that. So, and I had my learning is that I do resort to the expertise. So I have here around the table, and we have here in the audience as Tanlo firm, they're very expert in the arbitration. So they whenever I have such, so they would be my partners in this, in the design itself. Again, to make sure that we have it rightly fit. and rightly in line with the nature of the engagement.
Yeah.
So the learning is that we got our partners, external partners, involved from the very beginning. Yeah.
That's helpful. So Muna, coming to Sudan, Egypt is probably it's fair to say, a more mature arbitration market. They have institutions like the Cairo Regional Center for Arbitration, and it has a rich history of arbitration. Sudan is at an earlier stage in its arbitration journey. What does the bank, do you use a lot of arbitration, increasing? What are your challenges? Because I'm sure they're different to NADA's.
Yeah, okay.
That's fine.
In fact, in Sudan, yeah, we're facing many problems and we have many challenges. Concerning banking, we don't have many cases going to arbitration because of many reasons. One of those reasons may be for me and for my bank, we have this mixed capital or mixed shareholders. Sometimes to convince them to go to arbitration is so difficult, as sometimes because of they don't like to go for this maybe sometimes affects the reputation of the bank. They don't like to go for these arbitrations, although arbitration it should be confidential, but as they have also, they not trust sometimes the Sudanese legal system. And this is one of the reasons, really. And we have also lack of expertise in the law professional who are working in arbitration. And we have also in our law, we have arbitration law 2016, opened the door for prolonged appeal for the arbitration as similar as appeal in the procedure of appeal in the court, the same. Yani if you go for the annulment, action of annulment, if you like to set aside if there is any challenge of international award, arbitration award, the same procedure followed in the court. In this appeal, here this is the same procedure in the annulment of the arbitration award, and this is maybe take a lot of time, and this is maybe one of the reasons why our institution don't like to go to the arbitration. The enforcement of arbitration facing many problems as well. We have cases of arbitration, but it's not so many as maybe in other countries, as they have system. As well, we don't have even arbitration center in Sudan. And specialized arbitration center. With that, we are looking for in the future to raise the capacity of the Sudan in this area of arbitration, and we look forward for this, inshallah.
That's very helpful. Thank you. The fact that you don't have an arbitration center, my view, and I think the view shared by many in the audience is in Africa we have plenty of arbitration centers. Sometimes I think we have too many. We need to consolidate it and share the arbitration centers rather than every country having one or two or more. The regional cooperation, I think, is important, and I hope Sudan takes advantage of its neighbors and the arbitration centers rather than setting up yet another one.
Hope so.
The other thing you touched on is the difficulties of arbitration. Does the bank try and negotiate disputes before they get to court or arbitration?
We prefer to first settle our dispute amicably, and this is here the in-house lawyer play a key role in doing this negotiation. Sometimes discussion, mutual discussion, a negotiation for meeting between the parties, so they can avoid going to arbitration as well. Even save resources, time and money. For that, we prefer to go for amicable settlement for our dispute, really.
Thank you. Now it comes to the oil industry. It's an industry which has had a huge amount of arbitration and litigation over the years. I hope UNOC does not have to face the same thing, but when we talk to more mature oil and gas industries, Egypt, Nigeria, and so on, it is rife with arbitrations. As a young company, what sort of challenges are you facing? What are you anticipating in the future? And what sort of precautions are you taking so that there is a smooth resolution of disputes when they arise, if they arise?
Thank you, Kamal. In regard to what we are anticipating and how we are managing, trying to mitigate the challenges we are anticipating in the future, I think I would just want to mention that when it comes to young companies, we have an opportunity of learning from the experience of those NOCs that have been in place for time immemorial. So what we're doing a lot is to be very clear, and also we are dealing with international joint ventures in most of our projects. We are not implementing projects on our own. We are looking out for joint venture partners. They also come with different interests when it comes to dispute resolution. But we are studying that against what the experience has been out there. And that is one of the mitigations we are looking at. In the recently concluded negotiations, one of the highly debated and negotiated provision was always the dispute resolution provision. When I started out my profession, actually that we used to refer to it as a boilerplate provision. So you'd cut and paste and then you say, I've concluded, we don't need to do much. When it comes to dispute resolution, we all know what we have to write there. But I recall clearly when we are negotiating the host government agreement, the tariff and transportation agreement, and there was a lot of time spent. At one point, we parked that particular provision and said it needs more time. And also, we are getting more creative when it comes to arbitration. Yes, we cannot just start out and say our starting point will be arbitration. We are saying no, we have to try and resolve these matters. Arbitration is not as cheap as everybody who wants to put it across. Arbitration sometimes is really very expensive in terms of the time, in terms of searching for the arbitrators, in terms of also the relations with the other parties, but also management sometimes is not very cognizant and very excited about us going out there, close doors, and we are negotiating. So one of the things we are trying to do is to also say what elements or what disputes can we exclude out of arbitration? Yes, we are going to go for international arbitration, but what elements can we exclude that have to be localized and be managed using the local systems? And one of the things we are trying to say, can taxation be managed locally? Can we be able to look at labor issues and manage them from a local level? Because you anticipate that there will be more of those coming up in the course of implementing a 25-year, 60-year project or agreement. So you're saying let those be in country and let the other significant investment items be the ones to be arbitrated out of the country. The other challenge we experience when you move away from the drafting itself and agreeing to the arbitration provision or the dispute resolution provision is also when a dispute arises, convincing management that actually the cost benefit analysis is positive when it comes to arbitration. It's the right step to take. Everybody does not want to take that decision. So it's escalated and you take more time trying to amicably resolve something that probably cannot be resolved. So we are very much awake to that. And one of the mitigations we are putting in place is to say, can we have a number of days to which we can tag amicable resolution? And once that fails, then we need to go to the next step. Is it negotiation? Is it mediation? And if that steps also, that fails, then we can go for arbitration. So having a clear time frame within which certain steps can be taken is also one of the mitigations that we are really adopting.
That's good to hear. The fact that you're using tiered dispute resolution clauses, so amicable negotiations followed by mediation followed by arbitration, is good. It's been done for many, many years, but I don't think companies take it as seriously. And so placing emphasis on putting a lot of resource in those negotiations and mediation will help you save a lot of money later on.
Indeed.
Which is brilliant.
Indeed. So we also look out for which elements can be managed by experts, where you don't necessarily have to go for arbitration, but rather you have an expert, because there are certain things which will not be arbitrated. You just need somebody who specializes in a particular area, say it's accounting, it's finance, and they give you the numbers, and the numbers can never lie. So you don't need to go for arbitration and then expend in that regard. So we are also being very much awake to those elements that require experts guidance, and then we identify them clearly in the agreements that we are negotiating. I think another touch to the other elements when it comes to the challenges, because also identifying the right arbitrators is also a critical issue. I had a matter sometime when I was in Talo, and we almost took a whole year trying to identify arbitrators and who is going to be the chair. So when you think about that process, if we had gone to court, hopefully would have got the judgment out. But we took a lot of time looking at amicable resolution, but also the parties took a while to agree on who would be the arbitrators for that matter. Every time a party would propose a particular party, they would say there's conflict of interest. So there were delaying tactics that were being used using that process. So in the end, you ask yourself, yes, we said we are going to arbitrate, but in terms of efficiency and time saving, is this the right forum that we are actually advocating for?
Did you select the right arbitrator in the end?
That's quite interesting. I think in the end, we had amicable resolution reign, and the matter was resolved at that level because there was a lot at stake for both parties.
Yeah.
Yes.
So being an NOC and part of government, and there are a number of lawyers here who represent NOCs in Africa, there is a tendency and an increasing trend to try and keep the arbitration domestic, at least the venue of the arbitration domestic, because it generates fees for the lawyers, it generates fees for the infrastructure, the hiring of conference rooms and ancillary services, which is good, because the legal fees and the service provider fees stay within the jurisdiction. Do you consciously, when you are drafting your clauses, think about that, keeping it domestic and helping the domestic legal industry? Because in the UK, the legal industry is about 60 to 80 billion pounds. I have no idea what the value would be in Africa. Maybe someone does. I'll be interested to know. But is that sort of thinking you go towards being a new company?
Yes, that's a very fantastic question. I think for me, that's one of the challenges we are encountering today. Because we are dealing with many international companies, the first statement they will make, we are not comfortable doing this. This is not a neutral ground. So yes, we advocate for that, but in terms of that being amiable to the other party, is one of the biggest challenges we are having today. There is less trust for the institutions that have been created within even just Africa, and they pose them from the aspect of this is not neutral ground. The experience is limited, and then you ask yourself, when are we going to build that trust if we don't test out the forums and the institutions that have been created within Africa? But that is one of our greatest challenges. But we advocate always to reduce in terms of, we think of the seat, we think of the venue, and we also normally think about the issues certainly of language and also the cost implications that are involved, because we want to do our best in terms of reducing the costs that are involved in the arbitration process. That's the only way you can be able to convince management that's actually more effective than litigation.
Yeah, it's a fascinating topic, and if we have time, I'd love to hear the views of some of the institutions, and there is one or two current and ex-attorney generals in the room. We'll come back to that if we have some time. Can I move on to the topic of external lawyers. All three of you will be appointing external lawyers from time to time, correct? And there are many external lawyers in the audience. What I would like to touch on now is your experience of how you select us as your external lawyers, and what do you really look for? What really impresses you and what really bothers you? And please you don't need to name names, of course, but please give us your candid views, because that's something we as external lawyers always talk a lot about, is what will our clients want? What should we put in our pitches? How should we price? What should we say by value add? Should we give free seminars and free secondments and this, that, and the other? But does any of that matter to you? So perhaps Nada, we can start with you.
So Kamal, I looked at that a bit, not very much in a standard way where each lawyer would be looking to it. So for me as an in-house lawyer, there are certain components that has to be there. So I always call it software and hardware. So basically the hardware are the skills, the knowledge, technicalities, all of those are a must to have, definitely. But for me, the most important part is the software, the mindset, basically the eager for high performance, being inspired to perform to the maximum. And of course, the spirit of partnership, where he's stepping in as a partner or an owner to the business, not just a service provider and not just a lawyer who would be advocating on XYZ and advising on the query, not advising on the objective itself. So there is a big merit behind such, basically, and accountability. So you're not going to step in, just provide advice and then that's it. No, you're part of this whole process from A to Z. You're accountable, and that's what I say, partnership spirit. And here will come accountability, ownership. Very much important element would be agility. The ability to adapt flexibly and with speed. Nowadays, everything is going with speed. So if you're not able to pick on that very quickly, you're out of the game. So this is very much important component. And another thing, business acumen. I'm picking some kind of, so I'm a bit Unilever, it's kind of business terminologies. And this is what Unilever always has been embedding in us. Business acumen is very much important element, knowing the business and knowing how we conduct our operations, because you're not coming out from this. If you come from outside and you know nothing about the business, so probably you're not going to provide the right fit solution. So it's very much important to know the business from in and out. So these kind of, I would say, recipes, it has to come in a very holistic and well-composed structure.
I like the use of hardware and software. We tend to call it soft skills and technical hard skills. Same thing.
Yes, it's there are it's basically the software, which the attributes, the how part basically.
And the role of partnerships, of course, it's one of the catchwords.
I've noticed that, yes.
Is very important, because in our relationship building with clients, we always talk about long-term sustainable relationships and partnerships, but hearing it from you is obviously important.
Yeah.
What has can you give me one example of what has really impressed you and what has really annoyed you in a real life scenario before I move on to Muna?
I would tell you more what has impressed me. So we were about to go for local production in a certain country, and we were very much basic in our thinking. We're very much basic in our ask and our need. And when I went across the external lawyer, this is basic what we need to do. So the level of innovation and how he was able to pave the way for more opportunities that would deliver for your ambitious and your objective. So this is again, touching on the mindset, touching on the software. What I wouldn't like in any external law firm basically is this connectivity. So again, it's not about serving on the piece, you're serving on this whole holistic project. So if I'm not able to ask the right questions, then you're accountable and asked to provide everything that would be related to the subject matter. So this what I always expect from my external partner, and it's an asset.
And the role of communication is key in this relationship.
100%, yes.
How has that changed in the last 2 years for you? Has it transitioned from email to face-to-face? Of course, it's been very difficult, but we were talking over lunch yesterday or today, I can't remember, but the role of instant messaging, WhatsApp, availability, not necessarily 24 hours a day, but just agile and the speed. Do you use that as a business?
In terms of the
external counsel, communication with your external partners and the ability to communicate, not just through email, but other means to be more agile.
It's always so. It's the means of communication that everyone has been using, and of course, it took us some time as we were shifting to the virtual. I would say virtual era, actually, because it's still continuing with us still. So, and again, that's agility, being able to adapt quickly and flexibly shift in this new setup of communication. That's, I think, to remarkably consider. So I didn't experience any kind of glitch, let's put it this way. We were able, all of us, so we were in our backstage, each of us were suffering in order to cope, and then very quickly we were up to the right level. So still the same means of communication. And by the way, I more go for this kind of instant messages than emails that we stay in your inbox for quite some time. So it gives more, I would say, it encourages for a high level of responsiveness, basically. And this is what you're trying to trigger in all of your communications.
Yeah, thank you. Sadly, my WhatsApp group has grown.
I don't do groups,
massively.
No groups. You know, in Unilever, they love groups. So whenever there is we're thinking of a project,
yes,
immediately a group. I'm not very nice when I receive such whatsoever participation call. I don't go on that because you're losing the essence of this kind of direct one-to-one communication that is way more valuable.
Yeah. Muna, what have you looked for in external counsel?
Usually hiring or selecting in the external lawyers or external counsel is subject to the bidding procedures according to our maybe most of the companies. But as in-house lawyer, we have to set the technical qualifications as well the profile which can facilitate the selecting of those external counsels. This can include like previous successful experience in the subject matter according to this dispute, and also experience in the region, in the same region or in the same state. As well, they have to know about the governing law. They have to have like good knowledge on the governing law of arbitration. We are looking also in this technical qualification. We put some influent language. The team should include some of those people who had the language of the respondent as well. They and be. I prefer also to be from one of them from the same nationality, so they can also facilitate the arbitration. Also, we look for absolutely for good reputation for the law firms, and also if they have good profile in specific financial disputes, and they have successful experience and expertise in the area, or as well on the subject, in the specific subject matter. For me, not go just for the law firm, even to select the advocate inside the law firm, and to nominate or to propose some names inside law firms that they have good experience and they have good profession. This is, I think this is the,
Thank you. And in
the
a market,
criteria we can use it in our company.
yes. And you appoint lawyers mainly in Sudan or in other parts of the world where you have?
Not necessarily inside Sudan, it can be outside Sudan. When we are doing this bidding procedure, it's open for all law firm all around the world.
Okay, interesting. 2 out of 3 of you.
But the fees also we put we put like ceiling for the fees. So
So the sky wouldn't be their limit, huh?
Yeah.
That's a smart move, Mona.
I was about to say before you took the words out of my mouth. I was about to say that 2 out of 3 of you have not mentioned fees. Fees. Is that a key driver, or are you looking for much more? Because as external lawyers, the first thing we look at is how cheap can we go? How much discount should we give? And we try and get into your mind, but maybe that's not a key driver.
So Kamal, it's not the key, but it's one of the essentials basically, but it's not on the top of the list because you cannot compromise on the other part, which is all of those things that Mona mentioned, along with what I have mentioned. These are uncompromisable. So fees, if it's dramatically away from the market, of course, otherwise you're doing something that is, I would be questioned for that. So it comes, but not on the top considerations. Let's put it this way.
Good.
Yeah.
For us, it is one of the top.
One of the top. Okay. I hope you're not going to say it is the top for UNOC. Now you have a panel system, which is very structured, and given it's a national oil company, and it is about to go into the renewal stage probably in the next few months. What sort of things have you looked for in the past and in appointing in firms? What has impressed you, Barbara?
Yes, when it comes to Uganda National Oil Company, and I think from even my past experience, certainly when we go out to the market before we can form a panel, or we can say we have selected a panel from whom we can choose whom to assign which work depending on their experience. One, we look at the law firms. When it comes to oil and gas, the aspects of national content are very critical. So we expect international law firms to come in a consortium, to bid in a consortium with also the local law firms, because we think, one, there is a learning opportunity for them. 2, there are synergies that come also with somebody who understands how government operates, the policies in country, the laws in country. So that's for us very important. So if an international law firm comes on its own, it's going to be a little bit difficult to understand which aspects will not require any national to participate in. So there is need to speak to how those elements will be managed when it comes to the local elements. The other critical aspect is around the commitment on turnaround time. We have to look out at the profile of these particular law firms. We look at the law firm itself in its entirety, but also we look at the team that is being proposed. Who is being proposed from that law firm to be the one who is going to be leading? Who is a leading partner? Who are the other associates who are being proposed? And we also look at the aspects of their reputation. Those are very critical to us because integrity is one of the key things. And when you're dealing also with international law firms, we actually can't lock ourselves out of issues to do with the past litigation, the past record, any adverse reports that have come with the law firms and how those are being managed. So yes, we shall be inquiring to look out at any adverse reports about that particular law firm and also the individuals themselves who are being proposed. When it comes to money matters, certainly that's also very important for us because we expect a law firm to help us to mitigate on costs. These are already capital intensive projects. So you do not want the cost to also be blown away when it comes to disputes. We also look out at the projects that those particular law firms have handled, the disputes they have handled, and how creative and how innovative they have been. Because you don't want to be losing out on opportunities where you can settle just because your interests, the interests of the law firm are basically to maximize on the amount of money they can make out of a particular case. So we also want to see very proactive law firms coming on board. People who have been really very innovative in terms of solutions. And also we are looking at people who understand the business. It's very difficult. I know we're trying to build on experience, most especially for the local law firms, but also it's very critical that somebody has had interest, at least in the energy industry, to understand how it plays out, whether through trainings. It should be very evident in the profile that is being submitted, or in the proposal that is being put on the table, that actually this law firm is very much interested in our business, and also a proper understanding of our projects. Do you have a clear understanding of our projects? Because we have a website where we speak to these projects, and then you find some of the bids, they come in and there is no way, they are not even giving an insight about their understanding of what Uganda National Company does, all other national oil companies have done, or even the IOCs themselves, what they do out there in the market, and how they have been able to come up with more practical, pragmatic solutions when it comes to the challenges that they encounter. So we look out to see the cost management elements. Are you proposing anything? Will you be giving us some fixed fees when it comes to those cases, or you're just going to be timing us and saying, oh, I've invested 1,000 hours and that basically that's what I'm going to go for and charge you. So we want to see some creativity also when it comes to the billing system in those bids that are being proposed, but also the issues of value add. Are you training? Are you proposing any trainings? Are you proposing something to also enhance the capacity of the teams so that we can make less mistakes and less disputes arising out of our project implementation?
Thank you. There's a lot to think about there. I've been taking furious notes.
Yeah.
You touched on one point, which leads me into the last area, the very important topic of diversity. And perhaps, Barbara, I start with you. Diversity is top of the agenda in legal circles nowadays, as well as corporate circles. Gender diversity, we have a all-female panel here. What has been your internal experience on the promotion of female leadership? And of course, all of you have done very well on that front, but what is your experience of gender diversity and progression? And what do you expect of external firms? Do you expect firms to put diverse teams? And lastly, if you have the experience, how can we promote more African arbitrators into our arbitrations? Please take your pick on one or all of them. Starting with you, Barbara.
Okay, thank you. I think diversity is one of the topical issues of late. When you move away from climate change and sustainability, diversity, inclusion, and equity is another key topic that is out there. And it's something none of us can omit in whatever project we're trying to implement. We need to keep focus on that area. Recently, I was checking out the statistics when it comes to diversity, even when it comes to international arbitration. And I found some interesting statistics that probably are very sad, but are telling us that we are on a journey. I think when I checked out the report that was issued, I think in 2021 or 2020, ICC was, I think, having from the appointments that they had effected in that particular year, only 23% were women. And most of those women came in from the UK, they came in from Switzerland, France, and then the US. So there were few that were coming in from Africa, which is really very disappointing for me as a female lawyer. Then when you look at also the other institutions, also them, they are struggling. The numbers are within the region of 33%, and nobody was going even up to 40% when it comes to female arbitrators. And to my mind, what came to mind was what we need to do to be able to change that trajectory. And I think one of the things is this particular conference you have organized today, that has been organized where we are seeing more women come on board and talk and express interest in arbitration. I think that's one way of the women coming out there and saying, we have the potential, we have the experience, we have the capacity to actually be arbitrators. But also there is need, I think, to be very deliberate in our choice of arbitrators, and to always insist that the panel should at least have somebody who is female. So I think that can also drive seeing more female arbitrators come on board. The other key thing, I think the institutions also have to be deliberate in terms of their appointments to make sure that when they're appointing, at least they encourage more women to actually participate in that process. And if it means headhunting those ladies, they should be able to headhunt the female lawyers to participate and become part of the panels or the arbitrators that are available on board. So I think it's a journey, but we need to be very conscious about it. And we need to be very deliberate in making steps that actually will lead us where we want to be. But yes, it's very disappointing when you look at the statistics, although they are expressed to be an improvement from the past 4 years. When it comes to Uganda National Oil Company as an entity, as a government institution, even when it comes to budgetary needs and also putting them before Parliament, one of the areas where we are measured is basically on diversity, inclusion, and equity, because we have an Equal Opportunities Commission that actually looks at it and determines how are you progressing in that area. It's very critical in our constitution, has been well articulated, but also measures have been put in place to ensure that it's just not theoretical, but rather it's fully implemented and embedded, not just by the private sector, but also the government institutions. Now, within the National Oil Company itself, we have a diversity, inclusion, and equity committee that is responsible to ensure that we embrace diversity, equality, and inclusion. And indeed, even us as lawyers, the legal department, when you're looking at our panel, we definitely want to see that we see more women being proposed by the different law firms that will be participating in that particular bid. That's all I can say.
Thank you very much. That's a lot to touch on and cover. Nada, perhaps I can turn to you.
Gender equality and women empowerment, this actually, talking about that from the lens of Unilever, it sits on the top of agenda of Unilever. And it's not less important from our growth agenda, just to show the magnitude. As a business growth-driven, as a growth-driven company, so gender equality is very equal to our growth agenda. And making sense, I have seen the McKinsey global report where they were saying that if women would be taking the role of men in the labor economy, that would bring that would add 28 trillion USD to the global GDP. Can you imagine the magnitude?
Yeah, it's huge.
And more record to add here, Kofi Annan once said that in order to lead for the only tool that would effectively lead for development is women empowerment. So all of that will show how essential women is in the global growth, in the development in general. I want to go out more from records and speak more from the heart, basically. Sure. And it's so we don't call for women empowerment just a kind of ego thing where we're left behind. So please, we want to be there. This is not why we're calling for women empowerment, basically. But we want to empower women. We want them to step at the front. We want to give them access so that they're able to promote for the rights of your wife, your daughter, your sister, and all of the women that is in your life as men in their different capacities. So we want to do good for the society. We want to do good by empowering women, basically. So that would be more of our enabler. And to admit, and just so that no one would take this on me, we cannot do that if we don't have the other gender, men, support. But it's more of the proactive support. So it's not just wearing badges and posting on Twitter. No, it's more of the doer part here. It's more of supporting by action. So if you look for the successful women around the world, they wouldn't have been in their place if they did by their men. If their men did not choose to support, so there's more of an action here. So thank you. Actually, that's coming very much from the heart. So it's the he for she. And if you go on the UN, you're going to see there are very good initiatives. How we're asking he to support she, because it cannot go without the belief of he and she, basically. So the ask here is that men support women to break through the glass ceiling and to reach out and to be fully empowered. This is the call, actually, I would say call into action, but it's more something coming from the heart, and then of course reflected in clear execution. Another thing I would bring into this topic is the stereotype. So we're asking for actions, but there are other occasions where we ask nothing, not to do, not to go with the stereotype, because the biggest force that holds the women empowerment is stereotype. These kind of harmful social norms that limit expectation on what women can do, what women should do. This is really holding us back from the women empowerment. And they are very much outdated, but it's still there. It's still there, and we need to pull that from our mind, and we need to encourage everyone that not to go with these kind of stereotypes. Speaking about Unilever on that part specifically, Unilever has been tackling the stereotype by, in their advertisement, you're going to see they are empowering women, and of course, with our business partners, distributors, customers, we're harnessing them to drive into more actions that empower women, creating job opportunities for women. So all of those kind of different initiatives, Unilever, as I said, is the core of the core, women empowerment. So, and we have our diversity and inclusion, the big function that goes from top to down. They've been always putting initiatives that is empowering women. So Unilever does have a holistic approach towards women empowerment, and we have shown big transparency and achievement on that. And I don't know if you're aware of Bloomberg brand equality report that comes every year. It shows the list, it lists the companies that is supporting women and empowering women. So that shows the level of transparency of the companies as they are working on this agenda.
Two very powerful messages with different angles.
It's completely different.
I'm sure we've heard you loud and clear. Muna, would you like to
I
tell
think
us?
they cover the issue, but just I would like to say that the studies shown that the mixed gender team, they always issued good decision more than one thinking group. And this is not me. This is the studies shown that, and this is the result of many studies. Equal participation in arbitration. This is not. It will not down estimate the role of established arbitrators. For that, we are calling the men here in this hall to encourage women in their law firms to help the women and assist the women to work together and to make like mixed gender team, and not to have all the role of this law for themselves. Thank you so much.
Thank you very much. Good reception, as you can tell. We can go on for a very long time. This is a topic which can probably take a few hours. We don't have that, unfortunately. Before we end, because we're running against time, I'd like two questions from the women in the audience, please, only. All right, let's go one and one.
That's a bias,
Okay,
Kamal, huh?
One and one.
Kamal, you're showing some bias here. We don't want them to be annoyed.
Okay. Any hands up? Edward Luke, in the front there, please.
Excellent presentations. One of the things I want to ask you is we spoke about a lot of diversity with respect to women, but no mention is made whatsoever about race. What's your position on that? Race and diversity in international trade?
Okay, let's have the second question as well, and then we can take both at the same time. Any other questions?
Racial discrimination. Gal, you did it. Yeah, race.
Okay, Godwin, go on. I can't see any other hands up, so.
Thank you. And thank you to the panel for what I thought was a very insightful session. My question to you is directed at Barbara. You talk about creativity in terms of expectation from the council, fees. That's what I'm going to. My question to you is this: do the corporates also exercise of creativity in configuring council's fees? And I say this because many times what you find is, oh, you have to review your fees, you have to scale the fees down. It's too expensive. Legal fees are seen as a cost center, right, for lawyers. That's the first point. And then the second point is disparity in terms of fees for both external counsel, and by external counsel here, I mean international counsel, and perhaps local counsel working on a particular transaction. From experience, you tend to find that they're doing literally the same thing. Local counsel is advising on perhaps local law issues, but they get paid considerably less sums than external or foreign counsel. How have you addressed these two scenarios?
Thank you. Who would like to go first to either of the questions or both of the questions? Some quick remarks. So the issue of are you creative in what do you do to be creative on fees, and do you see a disparity between local and international counsel when it comes to paying the fees? And the second question is about diversity of race. What are you doing? What are your thoughts about promoting more Africans onto arbitration panels? Correct? Yes, those two.
Okay, I'll attempt to go first. In terms of promoting the issue of race, I would want to say, I think when we're looking at diversity, it's not just about gender. I agree with you. It should extend beyond gender, and we look at the geographical locations even, and look at ethnicity, look at the issues of race, because when you look at the arbitrable aspects, they just don't touch a particular race, they don't touch a particular region only, or they don't touch gender only. But I think when you have different players within the arbitration tribunal who are from different races, it comes with different benefits. The cultural aspects have to be considered. And I think the reports I have read, they actually touch all those aspects. Although the aspect of women, I think, was a focus of the question today. But yes, indeed, the aspect of race, ethnicity, and the geographical placements of some of those tribunals is very critical. But I think what we want to see more also is the reporting. How accurate and how detailed is the reporting out there from the different institutions, so that we can do a better analysis when it comes to all those aspects that surround diversity and inclusion. In terms of the creativity from corporates themselves when it comes to legal fees, yes, we appreciate that we have to get quality services from our panels, from the outside counsel. We appreciate that outside counsel has to be compensated for the effort they put in and the expertise. That is well recognized. But also sometimes we see a bias where people say we are dealing with a corporate, the corporates have a lot of money. We saw their balance sheet the other day being advertised in the papers, most especially for those that are international companies that always are required to publicize whichever money they make. And sometimes the bills that come through are kind of astronomical. And we find it very difficult, even us who are supposed to act as a bridge between you and management, who are supposed to pay out this money, to be able to defend some of the bills that come through. So I think we need to cooperate. We need to work as a team, outside counsel and internal counsel, and also be very reasonable in terms of the fees and in terms of the costs that we quote for these law firms to be able to meet. But yes, indeed, we appreciate the effort. We appreciate the man hours that are put in, and we really need to pay and rightly compensate for those particular hours, but has to be very reasonable. And also you have to be mindful once you're in a corporate setting, that the costs play a lot in terms of your profits. So your profits you make as a company at the end of the day have to be less all the costs that have been incurred. So whatever costs we can bring down, we really have the responsibility and the mandate to actually bring them down. But yes, we are creative when it comes to legal costs. And that's why partly sometimes we say, let us internally, we generate some of the documents, we support you with witness statements, we support the law council and corroborate so that we can be able to reduce the amount of hours and even that you're going to invest in a particular case, but also we reduce the workload and we have a very expressed scope for external counsel so that we can be able to mitigate on the hours and the costs that will be arising.
Thank you. Nada?
Yeah, I want to echo what Barbara just lastly said is about how you go very innovative in customizing the deal so that you reduce the cost. And this is an approach that we do in Unilever, whereby you take more of the out of expertise parts like the drafts or and some of the logistics part, and the external would be taking the areas that needs the experience and the expertise, or we do more of a preliminary work and is subject to review from the external. So it's collaboration so that we are able, again, not to compromise on the quality of the service and not to compromise on the profile of the external lawyers. So you have to go innovative in how you get the deal to go and fly. Yes.
Thank you. Muna, last
Yes, diversity is not just gender. It is include, as you said, social and ethnic, and we are encouraging elimination of all kind of discrimination. Without any distinction as to race, sex, language, and all these things. For that, yes, the diversity should also include all this kind of diversity or kind of discrimination. Thank you.
Thank you very much. We've gone a little over time, but it was a fascinating session. I've learned a lot. I'm sure the audience has well. So thank you very much.
Good?
Yes.
The last? Thank you. Thank you. Alhamdulillah.
And I'm surprised that we went beyond the
All right, everyone. So we'll move to what you'll be happy to know will be the last session of today. We made a slight change to the program, and the leadership panel will take place tomorrow morning. So we can all enjoy a cocktail after this session. So this last session will be on the developments in recognition and enforcement of arbitral awards in Africa. And I'm going to call the moderator for this session, who's Ms. Julie Mulindi, who's an associate at Jikera and Vadgama Advocates in Kenya. Julie specializes in disputes, both before Kenyan courts and in arbitration. Thank you, Julie.
Thank you for that introduction. Well, I have the daunting task of moderating a session, the last session. I will please request for the session, for the audience to interact with our speakers. We intend for it to be lively. And as it was already mentioned, today's session will focus on developments in recognition and enforcement of arbitral awards in Africa. This is a very dicey and interesting topic. With me this evening is Mushtaq Nabdarkhan, who is a partner at BLC Roberts in Mauritius within the Dispute Resolution Department. And he is mainly involved in corporate, commercial, litigation, and arbitration. Mushtaq appears regularly before the Supreme Court of Mauritius in shareholder disputes, banking litigation, and construction disputes, among others. Mushtaq? On the panel is also Dr. Fidel Masengo, who is the former Secretary General of Kigali International Arbitration Center. And he is a partner at Juris Chambers. He teaches international economic law, international competition law at Kigali Independent University. Of course, since he's a doctor, he lectures at the master's level. We had one speaker, Abbas Ismail, who is a partner at Anjawala and Kana. He sends his apologies, unfortunately he got sick. But stepping in for him on very short notice is Julian Kavaruganda, a founder and senior partner of Case Solutions and Partners in Kigali, Rwanda. Julian has over 17 years of experience practicing law at the Brussels and Rwanda Bar Associations. And last but not least is Sanjeev Kagram, who is a partner at ABN Patel in Mombasa, Kenya. Sanjeev has more than 20 years experience in commercial litigation and significant expertise, particularly in commercial, construction, and marine disputes. And Sanjeev has presented a number of papers on arbitration and alternative dispute resolution in Kenya and international forums. Thank you all for being here today. Now, as I said, we intend for this session to be interactive, and we will be throwing questions to the audience. And to start off with, Mushtaq, not all countries are parties to the New York Convention, which is key in the recognition and enforcement of arbitral awards. But this is not necessarily reflective of recognition and enforcement of arbitral awards. Could you please share your perspective on this?
Yes, thank you very much, Julie. And thank you everyone for still being there at such a late hour in the day, listening to recognition and enforcement of awards. So yes, in my research, I found out that there are 12 African jurisdictions who are still not parties to the New York Convention. And whilst is that reflective of the development of arbitration law in those jurisdictions? Not necessarily, because I've found that there are some jurisdictions like Gambia who have passed their own Alternative Dispute Resolution Act of 2005, and they replicate almost word for word the grounds that are found in the New York Convention on Recognition and Enforcement. So that's one way of domestically importing the New York Convention without the country being a party to it. Then there's a very interesting instrument called Member States of OHADA, so the Organization for the Harmonization of Business Law in Africa. So that Pan-African organization has got its own uniform act on arbitration. And if you go through that uniform act, it has many common features with the ancestral model law. And also on recognition and enforcement, there are many similarities with the New York Convention. So member states who are parties to the OHADA Treaty would also adopt the Uniform Act. And out of those 12 jurisdictions who are not parties to the New York Convention, there are 5 who are members of OHADA and therefore have the benefit of that Pan-African Uniform Act when it comes to recognition and enforcement of awards. And then there are some other countries who try to tailor-make their own arbitration laws. Sometimes it's not very developed, and you will find in those jurisdictions that they try to replicate what they would do for the recognition and enforcement of judgments. They try to replicate that for the recognition and enforcement of foreign awards. And therefore, you do get commonalities like the court deciding on recognition will not go into the merits of the dispute, and also they will not give recognition to an award that goes against the public policy of the country. But the inconveniences are things like double exequatur, so that they will insist on the award being recognized in the court of the seat before they will recognize it. And oftentimes they will also impose the requirement of reciprocity. So if it's a Libyan court, for example, considering whether to enforce an award, that court will want to see whether the country where the award comes from recognizes Libyan judgments. So reciprocity will be maybe a hindrance to enforcement. So those are 3 broad methods that you would find in those different jurisdictions. I don't know if we have time to get into technical detail of Uniform Act.
I think someone will be presenting tomorrow on the OHADA Treaty.
Yes.
So probably they can elaborate on the Uniform Act. But is there someone who's from a country, just to speak briefly from the audience, someone whose country is a party to the OHADA Treaty, just to elaborate what recognition and enforcement is in that jurisdiction? Anyone? Yes, there's a hand at the back.
So if I understand, you would like to know whether there is any specific provision regarding enforcement and recognition of awards in the other countries. Is this your question?
Maybe the experience in your jurisdiction on recognition and enforcement of awards under the OHADA Treaty.
So first of all, I need to say that you have a specific regime which applies to have OHADA Treaty is twofold. You have one system which is governed by the rules of the Court of Justice and Arbitration, which is any institutional arbitrations, and then you have the Uniform Act that is mentioned. So they both have 2 different regimes of the actual enforcement and arbitration. The Common Court of Justice and Arbitration, you have the civil, you have electoral law. Whatever happens at the end of this time, you have executory order which is given by the president of the court. And then from that, you can enforce your award in any of the 17 countries of the world. That's one part. On the other hand, if the award is governed by the Reform Act on Arbitration, then we need to go first before the competent courts in any of the 70 countries, either where the award was rendered or where the award is going to be enforced. Then, if there is a challenge to the award, it will be handled by the local courts that has jurisdiction over the matter in first level. Then, if there is an appeal to that, we go before the Court of Justice and Arbitration, which will make a final ruling on the case. So, if you stop at the stage of the local courts and there is no challenge to that decision, then you can challenge only in the country where you got the executory decision. That means, for instance, if you have an award from Senegal, you need to enforce it, let's say, in Cote d'Ivoire or in Benin. You need to go in each of those countries to get executory. Because there is no executory level with regard to the reform. Now, the challenge to the award, you go before the Court of Justice, then you have final decision, which is enforced in certain countries. And one last point very quickly, almost all the 17 countries people they necessarily apply.
Now, if I may throw just a spanner into the works, under the OHADA Treaty are the recognition and enforcement of arbitral awards. Would you say the courts are pro-arbitration, or do they have concerns with recognizing and enforcing those awards? Just in under 30 seconds.
That's a very challenging question. It depends on the jurisdiction, it depends on whether it's or a local court. I would say that generally, yes, it is quite easy to enforce, even though sometimes you have some challenges which have nothing to do with the challenge process itself. You have some other factors in the countries. For instance, when you have an executory order, in some of the countries, we will see that when you go in the country where you need to enforce it, you need to have, there is a stamp, a special stamp in the order that you give to your bailiff or enforcement agent that will go and enforce the award. I know of at least one case many years ago in Cameroon where there was an award that has been entered for almost 10 years has not been enforced. That was, I think, the isolated case. Now, there is many issues in which you hear people offenses saying that some of the courts they are kind of they are very eager to move to a court. I think that is a quite important issue. So in short, I would say that generally speaking, it's easy to get executory, but enforcement sometimes was an issue which do not always have to move themselves, but some other issues or political context.
Thank you so much for your contributions. So just borrowing from that, Mushtaq, the New York Convention is one of the most successful UN treaties on international and trade law.
Yes.
What are one of the obvious disadvantages of not being a party to the New York Convention?
Well, it's a theme that we've heard since the morning, that there is investment on the continent, and as part of investment, investors want to know how disputes are going to be resolved. And if arbitration is the preferred method of dispute resolution, obviously the New York Convention comes with a stamp of the seriousness of the jurisdiction to adhere to an instrument that more than 160 countries have adhered to. And most countries are familiar with grounds for recognition and for refusing recognition and enforcement in Article 5 of the New York Convention. There will be the advantage of case law of such a country developing in line with international practice, and overall, investors will be more comfortable working with an instrument they're familiar with, rather than trying to understand the specific arbitration laws of each country. So there are definitely advantages to being part of the New York Convention.
Now, what has been your experience on recognition and enforcement of awards under the New York Convention? And I know I learned yesterday night that you had actually acted in one of the most popular cases on this topic, which is State Trading Corporation and Betamax. So could you give us a comment on that? And also your article on why Mauritius, a national court in support of international arbitration.
Yes, I knew that, being from Mauritius, Betamax would have come up. I didn't act personally for STC, but one of my partners did. In fact, if you look at the record of the Mauritius court, we adopted our International Arbitration Act in 2008, and all the cases that went before the court challenging awards, I would say that STC versus Betamax aside, there was a record of always recognizing and enforcing awards and not allowing challenges for example, inability to present case. One of the first cases was about whether arbitral awards are in compliance with the Constitution. So all those challenges had been fended off until we had STC versus Betamax, which was about a contract entered into, contract of affreightment to transport petroleum products to Mauritius. 2015, the government decided to stop using Betamax as a supplier, and Betamax served a notice of termination. And one of the issues in that case was whether the contract entered into had to be in compliance with the Public Procurement Act. It was not in dispute that the procedures in the Act had not been followed, but the question was whether there were regulations that exempted STC from having to follow those procedures. So that was one issue in the arbitration. So it went to arbitration. The arbitrator ruled in favor of Betamax, awarded $150 million of damages. And then the STC applied to the Supreme Court to set aside the award. Now, the Supreme Court, under the ground of public policy, said that the Public Procurement Act is part of the fundamental legal order of Mauritius. So it's part of the kind of norm of our law, which is part of international public policy, and not complying with the Public Procurement Act meant that the contract and therefore the award was against public policy. So it set aside the award on that ground. Mauritius appeals, you can appeal from the Supreme Court of Mauritius to the Privy Council in London. And the judges in London said that, well, the arbitrator had decided on that point whether the Public Procurement Act had to be followed. That was an exercise of interpretation of the law. And although the Supreme Court is kind of guardian of public policy in Mauritius, it could not go behind that exercise of interpretation. So the Privy Council drew a distinction between an interpretation exercise of the arbitrator on a point of law, which the court cannot overturn, and a pure public policy argument. So that was the essential finding of the Privy Council, that the Supreme Court could not go behind that point of interpretation. And then as an alternative ground, it said, well, in any event, the Supreme Court was wrong in the interpretation of the Public Procurement Act and whether there was an exemption. Now, there have been many points made about Betamax when it came out, and it was the first case where the Supreme Court had set aside an award. And the comments that were going was what's happening to the jurisdiction of Mauritius? Has it suddenly become anti-arbitration? And I thought that there was a lot of messages that were going in that sense, which were a bit unfair on the jurisdiction, because firstly, if you look at the Supreme Court judgment, it was 45 pages. The Privy Council judgment was 42 pages, so 87 pages of judgment. So meaning that the issues in the case were quite complex. And that then it was the first Supreme Court judgment that set aside an award. And thirdly, we do have the provisions in our law which allow the Supreme Court to consider whether to set aside an award. If the message was, well, because the Supreme Court has done that, it means that the jurisdiction has become anti-arbitration, then it means that we should do away altogether with the provision, section 39, about challenges to award. So ultimately, Betamax, not being happy with the Supreme Court judgment, went to the ultimate recourse of appeal of the Privy Council and won. And I commented on that when I was asked by a journalist. It's a celebration for me of the rule of law, that you can go through those different steps, challenge, and ultimately State Rating Corporation lost. And within a week or so, the state of Mauritius paid the award. So that's my overall analysis of Betamax.
Thank you so much, Mushtaq, for that. And this will tie in with what you're going to speak about, Julian, which is public policy and how it has been interpreted in Africa. Maybe what we can do, you can speak about the Rwandese experience, and then Sanjeev, you can make comments on the Kenyan experience on public policy.
Yes, so for Rwanda, and I'm also speaking for Abbas, who was not here. So for Rwanda, the Chief Justice has been explaining the way it is appearing, and the public policy in Rwanda is usually considering the award, but no award has been set aside for KIAC, and only one from abroad. Usually what is being considered is what has been explained again, the reciprocity, and if it has been recognized in the country where it is coming from, but the reality of norm and culture in Rwanda is not particular. Usually we are open to market and pro-commercial and pro-arbitration. So for now, we don't have the issue in Rwanda, particularly of public policy issue for setting aside on using that sometimes excuse to not recognize a foreign arbitration. So the example, like the one I have for Zimbabwe, where they have been considering that if it is a judgment, a foreign award coming to Zimbabwe and being inequal or considered as unjust for Zimbabwean citizen, it can be set aside, which is considering the public policy very broadly and opening the door to setting aside any award that may be not fitting the political side or not fitting the judge feelings. So considering the morality, the culture and norms of a country may be opening the interpretation that can be not pro-arbitration and allowing a court to set aside many foreign award being issued. So for now, for Rwanda, we are still safe because of the records we have that the Chief Justice has been explaining this morning. And I think the Attorney General can confirm if needed, but the experience in the East African Court of Justice. But for now, for Rwanda, we are quite comfortable because even on gender sensitivity that can be used for some norms and awards that can be issued in that regards can be considered on property matters when a lady may be allowed to have some assets and is being challenged as not in line with some constitution, where in some jurisdiction, ladies cannot be allowed to have some ownership. This question is not a public policy in Rwanda, but it can be used in some jurisdiction to not approve or to set aside an award. But for Rwanda, for now, it's safe. But Kenya, I think my brother will be explaining a little bit more.
Thank you. First of all, let me say it's an honor to be speaking on this panel. Going into the question, Julie, the Kenyan experience, I think, is a mixed experience. And the difficulty that we have in Kenya, and it was very refreshing listening to the keynote address by the Honorable Chief Justice of Rwanda this morning. And it's something that perhaps we need to consider in terms of, putting public policy into a rubric that can be interpreted and predictable, into a predictable rubric. So in Kenya, the public policy definition is a very, very broad definition. And awards that are against public policy of Kenya are not enforceable if they're immoral, illegal, or would violate a clearly unacceptable manner of basic legal and or moral principles and values in Kenyan society. Now that is a very, very broad interpretation that's open to a subjective interpretation by different judges. We've had decisions where judges have interpreted public policy in a restrictive sense, so to speak. But there have been a number of occasions where they've opened up the definition and said it's not static, rather it's elastic and can be expanded because one may feel that the award or the process offends conceptions of justice in a manner that is considered highly offensive to Kenyan society morals. And that has led to difficulty in application of public policy concepts. And on one or two occasions, in fact, awards have been set aside on that basis. So my take on this would be, and take home would be, going by what the Honorable Chief Justice of Rwanda said this morning, is to try and find of course, we may not find a standard position, but to try and align the position within the continent so that there is a clearly identifiable and predictable public policy rubric where parties who are coming to enforce awards, even international awards, are able to predict the outcome of that enforcement proceeding within the jurisdiction.
Thank you for that, Sanjeev. And I agree with you that in Kenya, the interpretation of public policy is quite elastic. And some of the issues that have been brought out is whether there's a local interpretation of what public policy is, instead of, as far as foreign arbitral awards are concerned, instead of an international public policy interpretation. And on this, I want to bring it back to the audience. I am aware that South Africa has an International Arbitration Act, and that there were changes which were made on what must be done insofar as the recognition and enforcement of arbitral awards are concerned. So anyone from South Africa who wants to comment on that? Yes, Jonathan, it's good you volunteered yourself.
Inability to act fairly might not be sufficient to reach that provision. And the second point I also make is making the award is reduced to effect.
Thank you for that contribution. Is there anyone else from the audience who wants to speak and give their experience on public policy in terms of their jurisdiction? Yes?
I actually have a different question. My name is John.
Yes.
If allowed, I will pose my question.
Please proceed.
Yes. My question is, if anybody in the may answer the question. Article 5, 1, paragraph E of the New York Convention provides that the court before which enforcement of the foreign neutral law is sought may refuse enforcement. If paragraph E says if the award has not become binding on the parties, then I'm interested in the next part, which says the next situation, which is if that award has been set aside by the courts of the state. Now, there are many countries which which proceed on the basis that an award that has been set aside by the courts of the state does not stand to be enforced anywhere else. And there are other countries, and the number seems to be increasing now, including France, which believe that an award should have the vocation of being enforced in any country which finds it appropriate to allow it enforcement, irrespective of what has happened to that award at the seat. Now, I would like to know your take on this this division between the countries, such that these have become schools of thought. Yeah. And they both claim to be interpreting Article 5, 1E of the New York Convention. And France and the countries which follow its position in localizing the award from the decisions of the court of the seat. They say Article 5 says that a country before whose courts enforcement of the foreign neutral award is sought may, they say from the word may, they have discretion. So they ignore what happened at the seat and they look at whether it is appropriate for them to enforce that award. I don't know what your take is on that, the advantages, disadvantages of each of those approaches.
Fidel, do you want to take that?
Yeah, of course, I think we've been discussing this with my colleague who is asking the question in our cross arbitration. And of course, each side has its benefits and non-benefits. I shall go with the position of France because the judge who is called to decide on enforcement is the right person to assess the situation based on his own legislation and the president in that country. But that's my position because I want many countries to be pro-arbitration. And as you know, also I'm coming from a country which is now very pro-arbitration, whereby judges do respect the position of arbitrators at the maximum. I think they have given you the numbers for your information. Out of 12 cases that were challenged from Kigali International Arbitration Center for these last 3 years, none of them has been set aside. So you understand that our court is pro-arbitration. So we are like having that tendency of France. But for those countries also that think that if the award has been already set aside, then no need to bring that document to be. I do also understand their position because, before there are some requirement in the same New York Convention, as well as in many of the domestic legislation that has inspired by the ancestral model law that one of the requirement you should have a duly authenticated award or its copies, which is also authenticated. So if now the award you have is challenged by a judgment, setting aside that award, which is also duly authenticated, so you understand that you are causing confusion. But as I'm saying, I will go for the France position because it's progressive, but people who have also that other position, I do respect them because they are serious reason to think that if a document, a legal instrument has been invalidated in the host country, in the country that is supposed to approve it, there's no need to enforce it in other jurisdiction. But, it's a matter of perception and also understanding or being supportive to arbitration or not.
There's that person. Somebody.
Oh, sorry, there's someone's hand up.
With the last submission, been told is French students of this point. To my own mind, if this was allowed to become the prevailing jurisprudence globally, it would undermine international commercial arbitration completely. In my view, it would mean that you can forum shore until you find a court that is willing to enforce an award that is no longer an award in the country in which it was awarded. Why, to me, it is even more, it undermines the system even more seriously. It means that the forum, the seat of the arbitration, the courts in the seat of the arbitration may have made multiple interventions permitted by law. And all those multiple interventions, including the preservation of the subject matter of the arbitration, for example, are valid. But the ultimate arbitral award itself is invalid. To my mind, it is not. Secondly, now that I have thought, I was a bit surprised by reference to international public policy. I don't know what that is, because my own understanding of what we are trying to do when the award comes up for enforcement is to weigh the award against domestic sentiments. That is to say, for example, if an award was obtained in Kenya and it is sought to be enforced in Nigeria, if in Kenya there is what Nigerian courts consider good public policy, say fairness, gender fairness, racial, ethnic, and so on and so forth, are not reflected in Kenyan law. A Nigerian court is not obliged
To provide the signals.
For example, gambling. There are many countries for which gambling is not a legitimate commercial enterprise. So that if you obtain an award in Kenya, when forced a gambling debt, and you went to South Africa, a South African court says this violates not international public policy, the public policy of South Africa. Thank you very much.
Sure.
Thank you for that comment. I don't know whether, Julian, you want to react to that? Considering Abbas was talking about the indigenous and global perspective on public policy.
Yes, because it's the local manipulation that is a risk. And what we want to avoid is that one jurisdiction, considering that this award is not in line with the local public policy, they may set aside the award, but is not prohibiting another jurisdiction to find out that their own public policy allow that award to be enforced. So that is usually the position that many countries are taking to be pro arbitration. You check in your own jurisdiction, your own rules, your own culture, if there is something that award is that is being prohibited in your own jurisdiction. If not, you can go ahead and enforce that award. So it's in line with the risk is being locally, domestically. What do I consider to be unjust? What do I consider to be not in the norms of my country?
Okay, I saw a hand up somewhere here. Yes.
Karaoke.
Oh, okay, there are two hands. There's one there and one there. I'm hoping you can make comments under 1 minute.
Thank you. I think the issue is a very interesting issue. And the point really is the engagement of Article 7 of the New York Convention. The way the courts in the country where the awards are sort of enforced have interpreted a particular provision, which has been, depending on the enforcing court, goes through to means of permissiveness on what discretion in the court regarding the enforcement of an international law. Don't forget, the grounds that are stipulated in Article 5 are very limited grounds. And so the interpretation that have been given to that provision, Article 7, is that, look, the court retains a discretion, regardless of Article 5, whether or not to enforce an award, regardless of the provision of Article 5. It discretion of the courts of the enforcing state to enforce. And that is why you see in France and the United States of America, depending on, again, public policy issues that have been engaged, then the awards may be either enforced or they will be certified. I was involved in one of the first cases where we had an award set aside by the Nigerian court, right? And then proceedings were issued in New York for the award. Thankfully, the New York court refused to enforce the award on the ground that the public policy configuration in Nigeria did not allow it to do so, but it recognized its discretion under Article 7 to either enforce or set aside. Thank you.
Thank you for that comment. Yes.
Good evening. My name is Karim Kimwekwa. I just want to stand up to be counted, and I'm the professor. Even on this point, without repeating anyone, Kamal here, he also wishes to stand up and be counted. On that point,
I can see the Kenyans. Now, Fidel, you can see there's a lot of discussion on the court's attitude.
Yeah.
And we can begin your part of the presentation. Based on your experience, can you explain to us the requirements and procedures for enforcement of foreign arbitral awards and issues observed in the practice when applying for enforcement?
Yeah, thanks a lot. I think a lot has been said already on the matter, and I want just to recall two things that has been said by my colleagues before just respond to the question. Number one, because I'm talking about the African case studies, I want to recall that 42 African countries have signed the New York Convention. Only 8 are remaining. So this says a lot about at least what did the court attitude. Number two, many of the legislation in African countries are ancestral model law based. So you understand that Article 35, 36 of the model law well integrated in many legislation of many countries. Even what has been said by my friend from Ivory Coast about OHADA, it's not really different with the ancestral model law. So this means that at least legislation is supportive. And when the legislation is supportive, judges are led by the legislation on one side. But on another side also, many of the judges, especially in Rwanda, I'm not now saying for all countries, have been trained in arbitration, especially commercial judges and have been trained to arbitration, and they understand the role of arbitration, and they see arbitration not as a competitor, but as an institution that comes, to help them deal with the backlog. That's another aspect to consider. So going to the requirement practically, as I've said before, enforcing a foreign arbitral award, they check at least 4 things. Number one, is there a duly authenticated award or its copy authenticated? Is there a convention of arbitration, an agreement of arbitration which is also authenticated or its copy? In our country, we also add the language because that it has to be in one of the 3 languages that are accepted in Rwanda. Those are main requirements, of course, also with the principle of reciprocity, because foreign awards are binding if also in the country where they've been taken, they also respect that reciprocity procedures. But to be able to respond to the right question about the attitude, you have to look at these 6 steps. Step number 1, during application for staying court proceedings, how it's done in courts. I can say that in our legislation, Article 9, but also the practice in Rwanda shows that whenever there is an arbitration agreement, court will send people to arbitration. That's the attitude is observed there. The second element of the response, it's when court is assisting with the appointment of the tribunal. In 6 cases that have been submitted for these last 2 years in our local courts for appointment of arbitrators, it has been done in less than 10 days. So courts have really appointed arbitrators. And in all those cases, arbitrators have been appointed. Number 3, it's during recognition and enforcement of interim measures. For interim measures, we do have some cases, 3 cases, where court have taken interim measures, even suspending arbitration proceedings, but I've gone far to look on the reason behind that. And I found that all those reasons are genuine. Mainly it's because they're like a court proceeding going on in the court, just for the time to wait for the decision from the court. And another aspect to consider is when the court is exercising its power under Article 34 to 36 of the model law on the ground of setting aside or refuse to enforce a foreign award. On that aspect also, we don't have any precedent in Rwanda, but my friend Kariuki is here, Professor Kariuki. He has written a good article in Kenyan legislation based on the Kenya arbitration law from 95. He gives some cases whereby, we can see that it's not very supportive there, but of course, he suggests also some improvement in legislation and the practice of the courts. The last aspect to consider, which is very crucial, is a court intervention after the award. On this, I just want to give you the case of Tanzania, which is really good. Actually, it's the court enforcement of $65 million award against the Tanzania electrical supply company, TANESCO. So that's a good thing. But when you come to Rwanda, actually, that's very interesting because, I've served at KIAC for 5 years. We've had many awards, over like 50 awards. All award against government and government entities where the government has lost have been totally enforced voluntary, or for those that have been challenging the court, none of them has been set aside. So you understand that our court had that power to use any of those grounds, including the public policy that we are saying. But as my predecessors are saying, it's not the wording of the law. Even the Article 37 of the Kenya Arbitration Act of 95, it's not poorly written. It's a matter of the judge, how the judge interprets it. So if the judge is pro-arbitration, he will give it a good effect. If the judge is not pro-arbitration, he will always find a way of blocking the award. So for us, I can say that all the cases that have been submitted to court, and actually 12 cases for these last 3 years from KIAC have been challenged, but none of them has been set aside. Only, as the Chief Judge said this morning, the one case of ad hoc was set aside for also a genuine reason, because the other party was not even informed about the proceedings. You understand that that's a ground for setting aside, as provided for in Article 51 of our legislation. Of course, also 36 sections of the Kenyan law and Ancestral model law also provide for that. So I'm saying that the attitude is good here. When it goes to other countries also, not that bad as well, because I've given you the example of Tanzania, and also legislation wide is really good. So if a judge can, interpret it on his own, it's not a general, attitude. It's just somebody with, his own understanding.
Thank you for that. What I'm understanding what you're saying from your research in terms of the African case studies is that most African courts will be willing to refer matters to arbitration, that they will provide interim measures which are sought by parties, and in terms of post-court intervention, that this is quite limited.
Yeah.
And I just want to know from the audience, is that also the position in your countries? Okay. Oh, yes, in terms of your court's attitudes, are they pro-arbitration in terms of reference of matters to arbitration, or the court issuing interim relief during the arbitration process, and in terms of post-court intervention as far as arbitration is concerned? Okay, yes.
Thank you. Yes, in Nigeria, the courts are very pro-arbitration. Only last year, we did this study, templates. I love this study. I think it's public document is publicly available, where we studied the Nigerian court's attitude to enforcing arbitration agreements, enforcing arbitral awards, both between state parties and commercial private individuals. What that result showed was that the Nigerian courts are generally pro-arbitration, and with specific regards to private parties, tends to, in more than 60% of the cases, or 70% of the cases, tend to enforce that term leaves or laws or agreement. But I think the only minor recent tend to perhaps intervene. So, but generally, we can look at.
Thank you for that. Now, Sanjeev, your presentation is on independence and impartiality of arbitrators. And I think this is a spot-on conversation for you because you are an arbitrator. So arbitration practitioners understand that the fundamental requirements of being independent and impartial. So why would a party wish to challenge an arbitrator's independence and impartiality? And I also want you to tie in the next question. How effectively can a challenge be mounted and what must one not do in such a challenge?
Julie, thank you. Well, as arbitrators, we all know how important the foundation of impartiality and independence is. I mean, you cannot compromise on that. And that is what promotes trust. That's what promotes trust in having arbitration as the preferred dispute resolution method rather than litigation. Challenges to arbitrators or awards based on impartiality and independence are not everyday events, as many of you will agree with me. And in many jurisdictions, particularly I think the English experience is that, they rarely succeed. Not to say they're not made, but they're rarely successful. Courts on the continent appear to be more willing to exercise supervisory jurisdiction. The Honorable Chief Justice of Rwanda in his keynote address mentioned that this morning. In certain countries within limited bounds where the boundaries are very clear. In others, the boundaries are a little more hazy, not so clear. Now, there's a recent decision that was delivered earlier this month in Kenya, where I think going by the principle of that decision, it seems to be right in what the judge said, in terms of where an arbitrator resisted the release of certain documents and under the rights to a fair trial, under the rights to information based on constitutional provisions, relief was sought and granted on release of those documents. However, the rules or the principles of what documents you release and not release have not been set out very clearly. So the danger is for example, under those rights, I ask the question, are arbitrators' notes then susceptible to release under those rights? We all know that arbitrators' notes are personal. Parties are not entitled to arbitrators' notes in most instances. And so where do you draw the line? Insofar as the reasons of challenge are concerned, and I'm conscious about time, so I'm going to be very brief on this. The most obvious one is a genuine desire to protect a party's interest. Of course, you don't want to partake in a process where the party is not confident about the independence and integrity of the arbitrator or the process itself. But there appears to be a collateral, opportunistic, tactical exercise to delay references by counsel who sees on minor fallible doubts as to independence and impartiality. So, it's a very fine line, and you've got to decide as counsel whether you really have grounds for making a challenge or not. Inevitably, when you make a challenge, to a certain extent, you're personalizing the issue. Tribunals do take objective views about this. for example, in England, many cases don't go to court because in obvious cases, arbitrators walk away and say, well, if my independence is being questioned, then I'm not going to insist. But again, it can be that can be abused by parties, particularly a party who feels that they're on the losing end, would start raising, infallible grounds to ask an arbitrator to disqualify or remove himself. So one has to be very, very careful. Mounting challenges, whatever the motivation may be, although the bar, I think, to sustain a successful challenge is quite high. Obviously, when you want to mount a challenge, the sources for mounting challenges are innumerable. You've got statute, arbitral rules, national laws that support that whole exercise. And different jurisdictions apply different tests. So they're varying degrees of tests, but inevitably it remains on the same standard. The standard's quite high. The IBA guidelines on conflicts of interest are quite useful. They provide the non-waivable, the waivable red lists, the orange list, the green list. So they provide a good guideline on this aspect. What not to do? I think the bottom line principle is, at all costs, avoid the credibility of the party that you're representing being adversely affected. Do not personalize the issue with the tribunal. Be very, very objective in your application. Avoid a tactical or a speculative challenge unless you must not make a tactical or speculative challenge unless there are good grounds for making a challenge. Many a times it's used to improve positions. I have seen it being made to improve bargaining positions, to try and get the other side to agree to a settlement. So there are all these virtues that one needs to be open about. But, you must avoid the party who you're representing being criticized either by the court or the tribunal itself. Because if that same arbitrator is then going to hear the award of merits or hear the matter of merits, you run the risk of having a psychological disadvantage to a certain extent.
Thank you for that, Sanjeev. Now, under 30 seconds, and I'll begin with Mushtaq, and then Fidel, and then Julian. Do you have any comments on impartiality and independence of arbitrators?
Yeah, I just want to, when I was talking, I got reminded about a recent case, because practice is really good also, whereby a state agency is involved in an international case, and the state attorney challenged the presiding arbitrator, and the arbitrator could not withdraw from the case, and the two other co-arbitrators confirmed that the arbitrator shall remain. They just brought the case to the court, and the court ordered the two arbitrators to make a formal decision, what they did, but the court couldn't decide to remove the arbitrator. And the case continued. The state attorney and the parties, other parties were involved in the case up to the completion. And now the case is for enforcement. So you understand that the independence is well respected here, because they could have used the court just to remove the arbitrator, but they couldn't do it.
Thank
so
you for
I just
that
want
contribution.
to give that experience. Yeah.
Thank you. Mushtaq, your parting comments on this as we close?
On impartiality?
Yes.
I have an anecdote about it. There was a domestic arbitration we acted, and there was a site visit, and some reason the arbitrator was speaking to my client, and then the other side said, well, there was a conversation held without the other side being present, and they just indicated that they would make a court challenge to the arbitrator. And the arbitrator he was angry about it, and then he said, well, if there's going to be a challenge and I have to defend myself in court, I will defend myself, because I don't think I've done anything wrong, but I'm jumping into the fray for that court case, and then I'm going to stop hearing. So we had to cancel the arbitration. In international arbitration matters, if you know about grounds for challenge, you should raise it at the earliest opportunity, and you have a certain number of days to do it. You can't keep it close to your chest and then wait at the end. If the award is not in your favor, use that. It will be scrutinized, and it won't be viewed very well if you've kept a potential ground and then try to use it at the end. You have a number of days to make that challenge under the Act.
Thank you, Mushtaq. Julian?
Yes, it's a tool you have to use carefully, because you create a bias among the arbitrator. They are human beings. So if that situation happens, they may be having in mind that you're using it because you already have a lost case. So that is a tool to be used very, very carefully. And on the side of the arbitrator, you have to appear, not only be impartial, but appear to be impartial. Like an arbitrator not disclosing that he's the neighbor of one of the party, it doesn't mean that he's not impartial, but being friend and neighbor of one of the parties, it's an information you should disclose. So to avoid a situation where you issue a good award, but it opened the door for somebody to challenge. So those are the small tools. On the public policy, the area where I wanted to emphasize the domestic things it's a little bit like the COVID jurisdiction application of rules. When you go to a country as a lawyer or giving an opinion, you have to check not only the jurisdiction where you depart from with the award, but also the jurisdiction where you're going, where you will be applying. Because on the COVID side, I've been going to Bahamas, moving from Rwanda to Nairobi, Nairobi to Qatar, Qatar to Miami, Miami to Nassau, Bahamas. Different rules. Yes. And I come to know that in Miami, if I pass through Europe, I couldn't enter Miami in US, because they have been preferring on COVID testing and on COVID rules. It was fine to come from Africa than come to Europe. It was amazing for me. So they have been allowing African coming from Middle East, then European from London and Belgium and France at that time. So you never know, you have to check whatever rules is applicable for the award to depart from. So if there is a stamp needed, if you have to go through the embassy to have an authentic document before coming to your jurisdiction, Rwanda, Kenya, or wherever, then when you reach there, like for Rwanda, if you pass through the Rwandan embassy legalization, you have afterwards to go through the Ministry of Foreign Affairs to have it approved, to make the stamp of the embassy valid in Rwanda. Then it's another step before going to court. But what is good is that after when you go to court, it's a formality. So you don't have to justify anything. It's just a formality. Thank you.
Thank you so much, gentlemen. I'm afraid we are out of time. Please let's appreciate our panelists. And thank you so much for an interactive discussion. You may speak to our panelists who are available, I hope, after this session or tomorrow. Thank you so much.
Thank you, Julie.
Yeah.
Thank you very much, everybody. Thank you very much to this wonderful panel. Just a few housekeeping messages as the panel takes their picture. First of all, thank you, everybody, for being so wonderful today. I know we were running a little late on the program, but it's mainly because people were so interested in what was being said on the panel. So that's a positive sign, and that's a good reason to be running late. So we're very grateful for your patience in that matter. I'd like to recognize Maclean today for being such a fantastic MC. So a round of applause for Maclean Lusimir. Thank you so much, Maclean, for taking time to help us with this. Housekeeping, the panel that's happening after this panel on the program, if you look at the program, we have one final panel that was expected to take place. Now we have decided to move that panel for tomorrow morning. So that means it will be tomorrow morning, and we start tomorrow morning at 8:45. So we'd be really grateful if you can come at 8:45 on the dot, perhaps even 8:40. So just that's one housekeeping. Second one is for those of you who are able and who are interested in attending the gala dinner for the African Arbitration Awards tomorrow evening, would you kindly RSVP on the email that has been sent out? We will be accommodating registered guests only, so kindly RSVP on that. You have to organize transportation and other logistics. So we'd really appreciate it if you could do that. So we can accommodate you. And last but definitely not least, we have drinks ready for you. A bit of alcohol after a very long day of listening to some really great information. So to help you take all of the information down, we have a lovely cocktail right outside. It is sponsored by AB Patel and Patel. So thank you very much. Yes. So thank you very much, ladies and gentlemen. Please do enjoy the cocktails right outside. Network, speak, talk. This is why we're here. And enjoy responsibly. And hopefully see you tomorrow at 8:45 in the morning. All right. Thank you.